Someone make it make sense.
Probably a couple.
Hello, everybody. By popular demand, we are back with Karen Reed. Oh, let me add this banner because we don't want to have the freaking court TV banner. There you go. Side note, in the interim, I since the last live stream, I pulled up the Commonwealth's motion for sanctions that just got released. It was filed on February 14th, but it didn't come out until after this hearing, actually. So it's like brand new. But also, big news for Zach Hughes' trial. I was able to obtain the actual motion in limine, the big one, right? The one that matters. And also then the motion to limit Brad Post's testimony as well. So both of those are huge and will give us, again, we heard the judge, we heard them discuss it in the pretrial, like I guess the day before the trial started and then the morning of the trial, first day of trial. So we heard a little bit about it, but that's going to give us some more insight too. So we will cover those tomorrow when we also cover the trial. So I was also getting those documents and setting up that live stream and making the thumbnail and everything. Hi, Fender. Woo! Yeah, it's I haven't had time to actually read it yet, but it didn't look like it was about the issues that they talk about today. Well, so motion for sanctions, one would think it was about sanctions pertaining to the ARCCA dudes, right? But because this was filed on February 14th, it's not related. I'm sure there will be an additional motion for sanctions filed subsequently to today's hearing. So, but yeah, it just came up. Did you already see this hearing from today, Fender? So anyway, but yes, shout out to Fender. And hopefully I know that Twiz and Heather both were requesting that I go ahead and cover this. So hopefully they will be able to be here as well. So let me see here. Yeah. Okay, cool. So we'll just jump right on in here.
Yay. All persons having any business before the Honorable Beverly Cannoli, Justice of the Norfolk Superior Court in and for the County of Norfolk. To our native, give your attendance and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
The hearings.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Yes.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Michigan.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed.
Good morning. Good morning.
All right, I was told counsel wanted to see me at sidebar.
Briefly, Judge.
Okay. The only fan. Oh, why are we? Okay. So for the
Morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night.
Okay.
And on behalf of Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor
I
to.
don't know what Twiz is saying. Oh my God. Hi, Twiz. Welcome back. Echoes of Clarity. I know, glad to see you again. I did watch her interview. And by the way, Fender, I hope you listened back from, was it yesterday with the turtle boy? Because I answered your question that you specifically, I don't remember what it is at this juncture, but there was something you said specifically to listen out for. And I haven't had time to do timestamps for it yet, but I did say, here's Fender's question. And then whatever that was. And anyway, so if you've listened to the rest of it, you would have heard that. But yes, welcome back everybody. And yes, I don't blame her for not looking up at the judge. Court TV has timestamps. However, they're not correct. So anyway, I'll just update this is related. It sounds like to the Gretchen, what's her face, boss. No offense to Gretchen.
Endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the
Yes,
date you
because they'll
said?
have it on or before March 1st.
Okay.
Oh, because that was quick. All right.
All right, so that motion is allowed by agreement, and the order is right here, Mr. Clerk.
That was the one ruling that Judge Bev
All right.
was fair.
Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay.
And I also have that
All right,
scheduling order.
so paper number 483, this is the motion to compel production of
Okay.
a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. In the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition
Okay.
in response. Do you have a paper number? Okay.
Is defense going first?
I'm sorry, the opposition too.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument. You can give me that.
506,
Great, thank you.
that's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Cool. Yay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court, the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account.
Yeah, this is really interesting. I'm excited to see what happened because remember where we left off last time with this was they were supposed to maybe go and view it, and there's been a bunch of filings. I can't even fucking keep it all straight. I've got all those filings. I still have to cover those. There's like a billion. Anyway, well, we're gonna learn now what happened. So
hired detective, as explained by Mr. Brennan. We met after court.
That's
Mr.
where
Brennan
it
told
is.
us that we did not need, we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present. If all the information was a download from some iCloud account, unnamed iCloud account, as long as that was videotaped, we were fine with it.
yeah, you have to make
and
it
that was
all one
basically
word.
the agreement.
Nightbot.
That was the information that we had at the time.
We love Nightbot.
We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, et cetera. That same afternoon, apparently Mr. Brennan went to the Canton Police Department
Be nice to me.
and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective at the time. He could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or retired detective's work computer's
Right,
iCloud, which
yeah.
is what Mr. Brennan believed at the time and what we were led to believe at the time.
So
So we asked for clarification.
So that matters. So remember we talked about this last time, how I thought it was very interesting how Miss Alan Jackson has made it very clear that he doesn't, while Hank Brennan, unfortunately for him, has to represent the Commonwealth, that these issues were before him and not really with his knowledge, right? Like, in other words, he's made it very clear that it's not that he thinks that Mr. Brennan was misrepresenting something in as it pertains to the Lallyport video, but that it was, so remember how we talked about this too, right? Like the enemy of the enemy is my friend. And it's like, they're all getting fucked by Canton PD and by the Lally and the rest of the office and all that, right? Similar thing. So he's saying that they were both led to believe it was on this personal computer of this detective. And then, oh, shocker, that's not the case. Now we're being misled again, you know?
Clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room.
Oh, is he changing his
We said
stance
that
on
you could
this?
videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And
Right.
all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage.
That's an interesting looking thing that he looks like he's like a tablet. It's very long. I wonder what that thing is. He's like taking, it's like an iPad, you know, like I have an iPad with like the Apple Pencil and you can like write, you know, so it's like that, but it's like a long version, a longy one.
On this either iCloud or video system.
Interesting.
We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory because the audit trail will tell us information that we
I don't know why, but every time it says audit trail, I just keep thinking bunny trail or rabbit trail. Like here comes Peter Cottontail. Anyone else?
otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial.
That is so funny. Dude, he said it, as soon as he said this, hold on, this is really funny. We were thinking alike, he and I, hold on. That's really funny.
We would think that in point of fact, he would want those same data as well. Mr. Brennan made
Literally, when he said that, I was about to pause it and say, well, yeah, because remember what a big deal Mr. Brennan made at the beginning about how, you know, he's so, and he, to our knowledge so far, he has been like, here's everything I have. I'm giving you stuff. I don't even know what it is here. Just have everything, you know, and I commented, and so did others. Well, he's a defense attorney. That makes sense. Like he, you know, it's like what, you know, the least you can hope if you've got a prosecutor, or in this case, a new, you know, special prosecutor, the least you can hope is being transparent and turning over discovery, right? Like that's the basics. Like that's at least a step in the right direction, right? And it's so funny because as soon as I was going to reference that was his philosophy at the get-go, blah, and then he looks like he's about to say the same thing, and he kind of started to say, "Beat me to it."
made a point of saying,
Hello.
when he first came on this case.
Welcome
Look, we
back.
want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They had it. We
Service.
want it. And now we're asking for the court to order it. I'll submit.
We'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice wrought upon the defense that
Oh,
half the
dear.
facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion
Why are
making
we rehashing
representations
this?
that weren't accurate, I no longer have the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more about the cameras.
Oh, no,
I never
sorry,
visited
Kat.
the station. I wanted to know
Not
about
like
the
this,
process. And I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was
Sorry,
there.
You wanted to do due diligence. By the way, there's a dude who I don't recognize or remember seeing before because there's usually to the right of our from our view to the right, beside Karen Reed's parents. There's usually it's like that's like a rotating seat, like musical chairs, if you will. Anyway, I don't recall seeing this dude there before. Does anyone know who he is, or have y'all seen him?
DGM Petro.
He'll have to move a
That
little bit.
he was the officer who would download video upon request. He
There we
never
go.
downloaded
There's
a 24-hour
Who's
period. He
that
was never asked to. There was never a motion.
There
to.
you go.
When the government would ask, or state police would ask for a download of a particular event, like the Lallyport area, he would download it. What he told me is that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then
Okay, I think I see where this is going. Remember how then he wasn't supposed to look at it ahead of time or whatever? He was like, we're going to do this together. I think where this is going is he looked ahead of time, maybe?
just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive.
I find that
But
Hard
I
to do.
called the defense, not only due diligence,
You said
professional
but.
courtesy to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the six of us were there. We had a conversation.
Mhm.
We said we would simply copy the video, and then
backroom conversation. We're gonna get some tea.
another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seemed if it's on videotape, it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed. Under the spirit of Brady violations and due process, it was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually
Right,
know
because-
exactly what they're looking for. It is a simple
God.
click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing
Oh
it.
dear.
And so we want
Is that
to
because of the cold?
meet our
that would be-
responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine you do it one day, but
They're saying if you want to do it with the command, you can do exclamation point high and then night up.
Be heard briefly,
Yes,
You want?
very, very briefly.
take your time.
Thank you.
For example, I'll do
Mr. Brennan's confidence notwithstanding.
this.
don't
Yeah,
say
there you
about
go.
that.
Sorry.
Pretty immaterial.
This is more important. No, I'm just kidding. Twiz is doing an example. I was just saying, if you want to do it to Leslie and Billy, if you want to do it via the command, you can do it the way Twiz just gave you a nice example. Are both of you guys here? Like, are there two people watching, or like, should I be addressing one or the other? Anyway, just
What his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on. This is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called
we can get a
electronic
better look at this dude's face here. The one who I'm like, who's that dude right here behind? Can you guys see my mouse right there? Who's that dude?
fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them
Oh,
have metadata on it.
Twiz, your favorite lady's back right here. Can you see my mouse in the red shirt? Remember how she was staring at you that one like 2 hearings ago? There she is.
So it's not difficult.
I think her name is
We're interested in the videos,
Esme.
but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want the
October 24th, did that video come with the metadata?
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, again, I'm no expert. My understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or store the video.
Mhm.
It will also have potentially some sort of video player, maybe a proprietary player on it. And then there's going to be the file. So that's what we're asking. This is the metadata associated with all those things. It's not a hard ask. It's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire, the hired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the video. What more can we do than to invite the defense themselves
Sharon's face.
to come
That's
into
funny.
the police department and take a look at the system? So if there's something they want, then we'll copy it.
Okay. Thank you very much.
Guess what? She'll take it under advisement. Right.
Mr. Yannetti, the next one should be fairly quick and simple. The motion for Pro Hac Vici. I asked you before when Mr. Alessi joined us, you have a rather vague, good cause exists to grant this motion because Mr. Betero, is that how you pronounce his name?
Yes.
Betero has specialized skill and knowledge in representing.
You're
the
joking me, Bev. you don't know how to pronounce that last name. Bullshit.
And in matters of this nature. I
Bullshit.
asked you last time what you mean by that. I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. Would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition. but-
So
Thank you.
someone remind me, where is Mark Better? Is he in New York? I thought he was in Massachusetts. So
Yeah.
Anywho.
All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel?
Okay, the next one's paper.
Have you heard briefly?
Yes,
Have you heard briefly?
yes.
Okay.
So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay,
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing.
Well, obviously,
very
that's the
fundamental
normal
right.
job.
And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Bedrow is also an attorney for Mr. Kearney. And that is
Oh.
something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship
Oh boy.
between
Oh
Ms.
boy.
Reed and Mr. Kearney.
Oh
There
boy.
is a history of documented evidence showing the sharing of discovery
Yeah,
between the
I
parties.
knew he was working with Turtle Boy and others. I didn't remember that he was in New York because he's so involved with everything in Massachusetts. I just assumed he was in Massachusetts. But thanks, Fender.
And inevitably,
this
that
is
discovery is
really a lot.
promoted in such a way that abuses,
Future's back. Hi, Future.
harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Bedrow is representing him for. Now, it's not
I'm
great
curious to
clarity.
see where he's going to go with this because there's not a conflict of interest here. So, like he said, it's funny because he even couched it. He's like, it's not an opposition. I just want to share my thoughts. It's like what you're going to make for dinner. Like, what the fuck? I don't know why she's letting him talk. If the defense had said that, she probably would have said no. Anyway,
But it's been represented that there is a relationship between Mr. Bedrow, Mr. Bradle, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Bedrow, Mr. Bradle, have an understanding with the defense attorneys in this case. That there's an ongoing long-term implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal
Curious.
with witnesses in this case that allegedly have been harassed and intimidated.
wait, what?
It is curious that
Okay.
that relation
Wow. Holy shit. Okay. So, did it already show that? Did it already show what's on his screen? I don't think that I didn't see that, but I might have been typing. So okay, I don't know who White Boy is. Turtle Boy is also Aiden Carney. Some people say Kearney, but he pronounces it Carney. So I'm gonna say Carney. I know it looks like it could be Kearney. Hi, Rochelle. Welcome back. Rochelle joins us from Delphi, Indiana. Told you I would remember it now. That's so funny. So, but what I'm just don't. So I'm up on all the stuff that's going on with the lawsuits involving Turtle Boy and the witness tampering. What's so funny is in Massachusetts, the statute regarding like witness tampering is absolutely fucking insane. It's like, I'm not going to pull it up, but it's something basically like if you, it's like if you wave at a witness, basically, I mean, I'm only mildly exaggerating here. If you like wave at a witness, the statute is such that they can then allege witness tampering. I mean, it's insane. So, so the shit going on with all that is crazy. And like, anyway, but it has nothing to do with Karen Reed, except for the fact that it's a lot of the same people, right, that are involved. Canton is a small town. It has nothing to do with like, it's a completely separate. So it's weird that he's now making these out. Like, look at what he's saying here. These are some bold accusations coming out of his mouth right now. Like, and didn't he say indicted? Because that implies hold on.
to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants.
Oh, co-defendants. Okay, co-defendants. As in that. But what the fuck is this about? Like, you're saying that why are these you're preaching to the wrong person. Like basically what he's saying is he feels like they should both be co-defendants. I mean, take it up with, not that you should or could or have any standing, but if you want to complain about it, you should be complaining about it to the people who are the plaintiffs in that lawsuit, who are not even in this courtroom. I don't think. I know there's like a number of people involved in that, but like that's not. If they wanted to name her as a co-defendant, they would have and could have. And honestly, they would have done so frivolously and it wouldn't have been surprising, but they didn't even do that. I don't, this is odd to me.
It's curious that given the indictments,
sure.
most of them that deal with witnesses in this case that allegedly have been
Yeah,
harassed.
I don't keep up with it either, but I did watch I covered the juror interview for obvious reasons. You probably saw that too, Future, because that was the request from Vendor. But also it was a great interview where we learned a whole lot. So that's the only time I've ever watched him. Again, typically because he generates a lot of that toxicity that you guys know I stay far away. Run away. Monty Python.
And intimidated. It is curious that relationship.
Yeah,
exists.
again though, but it's because that statute is freaking insane. With the witness tampering. Like I said, if you basically waive at a witness, I can try to pull it up so I can actually give you the exact, but it's really crazy. And Runkle has actually I don't remember when the last time was, but he had covered those a while back and went over all of the, anyway, it's completely, I remember hearing about this during the first trial and thinking, okay, that sounds really bad. But when you learn more about it and when you learn what the statute is, it's insane. And I'm sure it's going to get dismissed. It's ridiculous. So regardless of what anything else about Turtle Boy, what I can say is like those criminal indictments and like the lawsuits and stuff are frivolous and they're going to get dropped.
Relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte.
Mm-hmm.
It's important because we'll later talk about in a sanctions motion, a violation, a direct violation.
Yeah, there's no jury here, Rochelle, because this is just a hearing, a pretrial hearing. So there's no jury.
Of protective orders in this case. And the discovery in this case was provided to Special Attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery. And much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and corporate.
Right, exactly. And that's part of it too, right? Is like they basically, because they're witnesses and he's not, right? It's like they basically instigate it. And then it's like, because the statute is so crazy, it's like if you breathe, basically you can violate it. So like they instigate it and then they can get him in trouble. It's basically just, that's the whole thing. It's like creating a situation where you can then, make these accusations and stuff. So yeah. Yeah, I'd forgotten that
some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned.
I mean, the thing is in terms of for the criminal charges, he's part of the Commonwealth. So if he wants her to be named as a co-defendant, they can do that, right? You know what I mean? That's why I guess I went ahead. My brain first went to the civil stuff because it's like he does have control over what happens with criminal. You know what I mean? And the office does, and they're all sitting right there. So anyway, it's just funny
about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses and this information. If a court order won't protect it, then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications had with Mr. Kearney, over 29 calls each.
Thank you, Future, for
and so
not
to speculate, But having a mutual
Not to speculate, but
agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected
there's
information
no
was ever shared
conflict, though.
prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this
Right.
trial is going to happen.
Exactly. And if they could, they would have, right? The Commonwealth is not shy about bringing charges that are unfounded, right? So even if they, again, it's like, the fact that they haven't brought charges, this is stupid.
And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay. Mr. Yannetti, I have to consider
right,
everything.
yeah, will breach. Yeah, so that's the thing. You that's not how it works. Like there's no yeah, he should be making, if there is something that arises that becomes a conflict, that's when you raise the issue, right? You can't just say, I hope there's not an issue. Again, that's why he's like, I don't have an actual, because he can't. He's like, I don't have an actual opposition or objection. Just here's my thoughts. In other words, I think he's saying this again for the cameras because like there's not actually anything happening here.
That was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one, I believe, is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and or Metro Court. Relatively straightforward, but I'll hear you. Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer, make a copy so that we can identify pieces that we expect to use.
Rewind 20 seconds. Sorry, future. I just saw that. To look at, what's on his screen? Let me pull the banner down. Are we supposed to be able to see what's on the screen?
Between
Audio recordings in
it's
possession of
easy.
489.
Oh my God,
Commonwealth's
that
motion
is
to
so
amend
funny.
the December 5th order pertaining to audio recordings.
What is he doing? I mean, I doubt she was even live yet because she usually delays it, So is he like at the lawnerd shop? Like, what is he doing? Is he watching a stream? That is freaking hilarious. I think you probably said that. You're saying go back further than that? I want to know.
Issues in the affidavit.
Was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit.
the Commonwealth is entitled to a fair trial, and the witnesses are entitled to walk in this courtroom without being abused.
Oh, he had Runkle on there?
Thank you. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I
You
don't
must have
object.
been looking at
But the
past
Commonwealth
live
is entitled
streams
to.
or something.
The Commonwealth is entitled to a fair trial, and the witnesses are entitled to walk in this courtroom without being.
There's he can me.
Mr. Yannetti, I have to consider everything that was just said.
When does he do
I'll wait
Runkle?
for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and or Metro Court. Relatively straightforward, but I'll hear you. Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to
Uncle
it other
Andy,
than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay, there's no objection to this, is there?
No, Your Honor.
Of course, I'll provide defense copy if they want.
Yes.
That's amazing. So he had them both up. So he had them like in split screen because it's been a while since they've been on a stream together. God, a really long time. So he had Runkle and Edie be up together or something.
All right, so this is allowed. All right, so the next is paper 490, defendants rule 14 and 17, motion for court order authorizing defense access to the Lexus in Traverse and to the
Okay.
driveway at One Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to defendants rule 14 and 17 motion for court order authorizing defense access to the Lexus in Traverse and to the driveway at One Meadows Ave in Canton to conduct
So I
independent
wonder,
testing and analysis.
remember how we were talking about this on another live stream about how they need to test it out and see what happens if you actually back the vehicles into each other? I wonder if that's what they're going to do.
I assume counsel has seen this affidavit of Mr. Diller.
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today. And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well
Good night,
satisfy us. And I would ask.
Good night, future. Awesome. Hopefully you'll join us tomorrow. I'm going to be covering the Zachary Hughes. And by the way, if in case anyone missed it, I do have the documents for the motion in limine as well as the motion to limit the testimony of Brad Post. So we will cover those tomorrow as well as the testimony. And it looks like it'll be the defendant taking the stand. So, and I'll check the Discord. Thank you, Bender.
The court take no action on this motion until we've had a chance to view them, and we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's a spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested. Okay. All right. So no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Wait, which motion was
Would you like me to address both issues first, or?
I was in the Discord. Hold on.
Both issues.
Which motion?
So, Your Honor, take-
Oh my God.
493, defendant's motion to reconsider reciprocal discovery order, and
Okay.
paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first, or?
Both issues.
So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial, whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider.
Oh, that's awesome.
It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outlined in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to, Ms. McCabe, it was never mentioned anywhere that she spent an hour at the home, the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that that meeting did take place. And so, the Commonwealth, armed with that information.
Wait. Why was there a geofence in this case? Why was there a geofence? I don't even remember. Why would there be?
Went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. Secondly, with regard to the juvenile witness, as the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, we question what was done behind the scenes to, arrive at that conclusion as well. I also, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed, so I take responsibility for everything that's in there. But we also make the point that with regard to Trooper Proctor, it appears as though there was, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument, and he obviously uses derogatory language toward him as well. If we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but this is I won't say unique trial, but it's a rare trial that is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions.
Let's wait. When I said both, I thought there were 2 points that made up to.
Understood.
All right, so Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes their names on them, talking about theories of the case.
Yeah, you've
I
already
give it to
talked
the
about that,
defense.
Hank.
Because it's in my possession, custody, and control, I have no intention of calling an anonymous person. But because I have the information, because I am the Commonwealth, they're entitled to it.
Yes.
If we look under 14B, it's different for the defense. If they are going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways. Federal rules are very different. In state court, for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides. And that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. The only thing I would point out, Your Honor, is that with regard to the report of Jennifer McCabe, I should say, revealing this link meeting, that report wasn't provided to us until after she
right?
testified.
I know, it's just.
And I think this court remembers from the trial that there was sort of a rolling discovery that we received
No
even as the
kidding.
trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best.
Oh my
I will
God.
Continue to provide all discovery timely to the
Shut up.
defense.
Thank you.
I've been on the side where late discovery comes in a trial, and I never want that to happen.
No.
Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
No,
All right.
I don't know that even more is the answer. They'd probably rather have the proper discovery that they've asked for in the correct format that is not tampered with than extra discovery that isn't helpful. But in a perfect world, they would receive all of it anyway. But anyway.
Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with,
So you have the Commonwealth's response, right?
yes,
Where it doesn't object to some. Are you going to skip over those? Or
yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police
Yeah.
came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Lallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Lallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was
Crazy.
booked
I
into
agree.
evidence.
Totally.
You can't,
I
the
mean, it's
Commonwealth,
mind-boggling, right? And honestly, I will say, obviously, there's a lot of this that's the fault of Camden PD. There's also a lot of this that's the fault of the Commonwealth. But I will also just say, it's also the Judge Bev's fault, because you know what? In the first trial, both parties had a joint motion to, oh my God, what's the word I'm looking for? It wasn't why am I blanking on the word? They had a motion to, oh my God, why am I blanking on the word? Motion to push the trial date out, right? Why am I my brain just completely blanked on the word. Oh my God. Continue. That's of course motion to continue. Duh. Obviously, motion to continue. That's the word I'm looking for. They had a joint motion to continue the trial date, right? And she, very unusual, right? She denied that. So she's on the hook for this as well, for the fact that there's still, again, 10 items still pending, which is insane.
cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation?
Obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos, but that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize. First responding officer, Sergeant Link. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper, Guarino.
For sure.
Lieutenant Brian Tully. Trooper, Kathleen Prince. And Norfolk County District Attorney, Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically, in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Guarino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions.
So Twiz, if you're still listening, remember when you were asking about how this would be relevant for this case, and we were talking on this last night, and I think it was last night, and I was saying how I think it really comes down to Trooper Guarino, and because he did the cell phone stuff, and we were talking about how there's like all those missing text messages or messages that he quote unquote overlooked on the police officer Farwell's phone extraction. Anyway, so this is what they're getting to now as it pertains to Trooper Guarino, or she's getting to.
Also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Guarino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct, nothing to see here.
Yeah, over what was it, 30,000 texts, I think?
Yeah. When the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Guarino's credibility, bias, competency,
Here
and
it is.
ability to conduct an investigation in this case,
Yep.
where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that
So if
information.
it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back.
A
in
Weenus
2022,
motion,
and it was
oh dear.
ongoing.
All right, if somebody can tell us the paper number so we can find that.
Thank you, Your Honor, I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right, Mr. Brennan.
Ms. Spring?
It's important to represent facts accurately.
Oh my God, here we go.
And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance
Hypocrite.
behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request, I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all of the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto.
Wow.
And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Ms. Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case? Troopers work on many
Because of
cases.
the phone.
That case certainly has a public appeal to it because of the harshness of it,
This
the
is
sadness of it. But what does it have to do with this case?
this is awful. I hate this so much. I just hate this so much.
Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor.
Gross. Like he's like saying they're trying to exploit that case because it's so awful. Like that. It just.
Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady versus Maryland and Giglio, and most recently set out in McFarland and Graham. The Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the Department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth versus Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor. To the extent that any records beyond that was initially produced in March 19, 2024, please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCCA, and we'll discuss that in more detail when we get to the ARCCA motion, and expert discovery. We have provided, there is a difference between ARCCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The
I want to know.
discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCCA. And again, I'll delve into that when we talk about ARCCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right, so I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're
I-
over 500 at this point, so.
Yes.
All right. All right, so next we'll move on to the so-called ARCCA motion, Commonwealth's
Oh my
motion
God.
to exclude employees of ARCCA, paper 497, and the opposition 505. So, Mr. Brennan?
Okay, so I am pulling up, guys, something really important here. Let me update my ticker. We're going to refer to all the different things back that happened during the trial as it goes along.
Sure.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness.
So I have to just say, I found it interesting that some of the things that happened on this day, at this hearing, I found it interesting considering the Turtle Boy interview just happened, 2 days prior? And how, like, I would say that even for people, if they're pro Commonwealth or against Karen Reed or whatever, even for people that are on that, whatever, if they're all in that realm of that, I feel like the thing that they would hopefully even admit is that the defense hasn't done anything. Now, I could be wrong because I don't know. I don't hear from this. I don't get involved. I could be wrong, but I would imagine that they haven't said that the defense has done anything shady. Maybe, again, let me know if I'm wrong, but like, at least when you look at it objectively, there's not really been anything shady. Like the Commonwealth, right? There's lots of shady stuff there, right? But you know how like people who are, for example, people who are really uninformed as it pertains to the law and defense attorneys, there's like defense attorneys have that stigma, right? That stigma that they're dishonest and that they're slimy and all this and that, right? And it's unfortunate. It's not the case, maybe there's some that are like that, but because of that stigma, defense attorneys really, they try to do things and they're fighting for their client, right? But in terms of like breaking the rules, right? I guess, for example, a defense attorney might not be breaking any rules or doing anything wrong, but people might still see them as slimy or whatever. And whatever, because they're like, oh, how can you represent the defendant? Again, that stigma. But that's very different than like actually violating a rule or, doing something like that where it could be sanctionable. And so when it comes to this case, there's been tons of that from the Commonwealth. I can't think of anything. And again, I didn't watch anything pre-trial. I got in here first trial, but between the first trial up to now, I can't think of anything that people could say objectively that is like actually the defense doing something, again, in the legal definition of what could be something that is like sanctionable or violating a court order, things of that nature. So you have that. And then you have the Turtle Boy interview with that juror. And, when they talked about the ARCCA dudes, the crash daddies, and like the thing that has been so important, right, with this case is like, look, even the people who work for the feds said that this is impossible, right? The Commonwealth is is basically nuts for even trying to say that it happened with a vehicle. And so it's like you have the ARCCA dudes who are like, they're neutral, they're a third party, they're the best of the best. They had no incentive to say anything for the defense. It's like literally, it's the thing that everyone has relied on. It's like, well, this shuts down their entire case, right? And then you have this interview with this juror, and that they came up a lot in that discussion, and the thing that I find so interesting is that one of the things that the juror said that was really surprising when it comes to why maybe they didn't put more, more weight on that testimony, the people who wanted to convict, it's like, oh, well, this is just the defense trying to distract us. And this is the defense, they're just being shady, right? That type of thing, even though it's irrelevant and not accurate. But I find it really interesting that now, as it pertains to the ARCCA dudes, there's being allegations made here by Hank Brennan. It's like, again, even if you were someone who was like pro Commonwealth, whatever, I find it that there's got to be certain people who say, yes, it's how you can't diminish their credibility. The ARCCA dudes are the ARCCA dudes, right? It was like the one thing that no matter what, you would have a hard time finding anything to say bad about, right? Like, how could anyone say they're biased? How could anyone say they're not qualified? People couldn't. I find the timing interesting. And then now you have him attacking the thing that was so huge for them, right? So, okay.
It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here.
Okay, hang on. So let me pull this up. Wait, let me back it up a second, because June 10th, let's
The answer said not prep about ARCCA, and it was represented these. I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024,
okay, June 10th. I'm going to play it for a second. I'm going to find this day in trial.
we asked the defense about ARCCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government,
I find it.
it seemed to me, based on my limited experience, there was much more to the story. So I called.
Found it. Okay. So I'm going to back it up to hear how he how he portrays this, but I found this is when the ARCCA are first mentioned, okay, in this whole thing. So okay, let's take a look and see. This is actually well before the actual voir dire and the actual testimony. So I found, so this is June 10th. Okay. So let's see what happens here. And there's no subtitles available, but I don't think you guys need it anyways.
Defendant produce what the Commonwealth is entitled to under Rule 14 and what every criminal defendant in the Commonwealth of Massachusetts must produce to the prosecution. It was not until the day prior to trial on April 15, 2024, that the defendant provided notice of all their experts. During jury impanelment, the Commonwealth filed a renewed motion for reciprocal discovery, and the defendant was ordered within a week to produce the expert opinion testimony that the Commonwealth is entitled to. We are now entering, I believe, week 8 of the trial. The Commonwealth has not received any intended expert opinions, anything that those experts, any written reports, opinions, or anything that those experts have based their opinions on. Essentially, the defendant's strategic decisions not to retain their own expert, but rather rely on the U.S. Attorney's Office investigation does not alleviate them or relieve them from their Rule 14 obligations. As it pertains to Dr. Marie Russell, the Commonwealth did not receive notice that she's an intended expert until about week 6 of the trial on May 21st. And it wasn't until May 30th that the defendant provided a brief synopsis of what her expected testimony would be. Essentially, and looking at the balancing tests set forth by the case law, the Commonwealth was extremely surprised by this disclosure. And further, the Commonwealth would put that the defendant's delayed decisions to produce reciprocal discovery is in bad faith. It is intended to ambush the Commonwealth and conduct a trial by surprise. We are still receiving reciprocal discovery. Over the weekend, we received additional photographs that the defendant intends to use. The Commonwealth is extremely prejudiced by these delayed disclosures. So looking at all the balancing factors, exclusion of Dr. Russell is really the only remedy that's appropriate given that we are in week 8 of the trial. The Commonwealth cannot.
Why does this matter? There's going to be a lot of things said by Hank Brennan. Some of these are things that don't have a date. Other things do have a date. The timing matters. And what we're looking at is 3 main things, right? What happened? What was said when they first were talked about, right? When they first came up. Right now, I think this is the first time they come up in this trial was this day. And then also what happens surrounding the voir dire, right? What was the rules? What were they told on that day? And then also what was testified to at trial. So this is the first one in the chronological order, right? I believe this was the very first time we heard about them. And I remember it was like, whoa,
seek a continuance. The Commonwealth has their hands tied with how to effectively prepare for cross-examination of that witness as well as all the other witnesses. We don't have any materials. We don't know what the experts' precise opinions are and what they were testified to. And it's essentially, it is in bad faith and there's no less severe sanction. So the Commonwealth would move to exclude Dr. Russell. And at this point, we are essentially just seeking the reciprocal discovery that the Commonwealth is entitled to be able to effectively prepare cross-examination of these witnesses.
So this is so relevant, the reciprocal discovery. Okay.
This is so late in the game. Thank you very much.
All right, who's arguing this for the defendant?
There's no mic at council table, so I'm going to go to the podium with the court's permission.
Yes.
We need to be heard on this.
That's why we're here, Mr. Yannetti.
Thank you. I'd like to start with the most outrageous and false assertion that the Commonwealth made in its motion.
Can I just ask you, there's no jury here. Can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay. Because I don't need, the hyperbole.
Your Honor, I need to make my argument in the way that I think is most effective for my client. I will keep this brief and succinct, but I have points to make that I need to put on record.
Okay, and I'm the person you are trying to convince, correct?
I understand that. The Commonwealth, in a public filing, wrote the following on page 3 of its motion. Quote, during a pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is false. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm sorry?
I don't have that in my motion.
It's on page 3, Your Honor.
I'm going to go ahead a little bit because this is about Dr. Russell. We'll see where we get to the ARCCA.
It's about the 5th line down. Starts during a final pretrial hearing on February 15th, exactly as I said. Okay, so all right, we're not dealing with canine DNA.
Hyperbole I don't need. Could you please get
Oh dear.
Replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our right to argue that John O'Keefe's arm injuries were consistent with the dog attack. And I ask you, have they no shame? I'm sure it's not lost on this court
I love
that
it.
this false filing by the Commonwealth comes on the heels of their nefarious attempt to pass off an inverted video, a false video, before this good jury hearing this case. Never once during the direct examination of Sergeant Buchanan did they inquire or mention the fact that the video.
Can we please, all right, I'm going to stop you. Please direct your comments to Rule 14 and the reciprocal discovery obligations that the defense has. That's what this motion is. I know you have a speech you want to make, Mr.
It's
Yannetti.
not a, Your Honor, most respectfully, it's not a speech. It's
Okay,
a
so-
defense of being alleged to have committed bad faith.
So you've moved on from that. So please just focus on Rule 14 and let's do it in two separate parts. So you've changed, you're not calling Frank Sheridan,
No,
right?
we
You've
are
got-
calling Frank Sheridan.
All right, so you've got a new medical, Dr. Russell. We'll do that part of it separately. Tell me about
Yes.
what you've provided the Commonwealth on Chris Van E.
They've gotten his CV and they've gotten the substance of his opinion from us. And they've had that for a long time.
I
And
don't even remember what that guy testified to, y'all.
court, I believe,
Anyway.
has
Did you provide anything recently since the filing of the Commonwealth's motion, Mr. Yannetti?
not on Mr. Van Een, no.
What does the Commonwealth have on Mr. Van E?
I'm just going to skip past that because I don't even remember who he was. I remember thinking the name was, I didn't know how to spell it, but like I don't. Anyway, we want to get to the
Rule
crash
14.
daddies.
Similarly, what's outlined in the rest of the motion, that's all the expert evidence the Commonwealth has.
And exactly what his opinion is. All right, by the close of business tomorrow.
That's fine.
All right. Now regarding
Okay.
the three experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Okay.
Your Honor, we've provided everything
Here is the question. What have you provided?
that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I
them.
understand that.
These experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe
So this rule is referenced in this hearing, okay, that we are watching. And we don't have the written rule, to my knowledge, like it's not publicly available, but they're discussing it here.
that the defense is calling three witnesses that you've never spoken to and putting them on the stand here when
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings.
Okay, let's listen to that again. This is really important. This is really important.
for trial.
So I'm to believe that the defense is calling three witnesses that you've never spoken to and putting them on the stand here when
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it.
Only for coordination of their testimony and their background.
We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
And you have not complied with your Rule 14
we
obligations.
can't, Your Honor.
So,
We can't.
so you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their
Okay,
testimony.
that's fine, Your Honor.
All right.
Yep.
And now tell me about this ER doc. Is she an ER doc? I haven't seen her. She's not a pathologist,
Well,
correct?
she's a pathologist, but she has a lot of
We're
experience.
back to Dr. Russell. I'm going to see if they say anything else about the ARCCA dudes at this point.
You can get her here Wednesday.
It looks like they might not because I think this part's almost over.
Expect the voir dire of each of these witnesses. If in fact the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect the voir dire of each of these witnesses to take? I went and told the jury last week,
I'm sorry.
last week that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah.
Yes.
At least with regard to the, of course, at least with regard to the ARCCA witnesses, that's my co-counsel's bailiwick. He anticipates that unless there are, a substantial number of objections during the voir dire, he anticipates being able to accomplish that between 45 minutes to an hour with each of those three. With regard to Dr. Russell, we anticipate a half hour. Oh, I'm sorry, only two from ARCCA, that's right.
You're only calling two? Which two? Are you calling the two that are certified as accident reconstructionists?
Doctors Rentschler and Wolfe. Yes.
Or audio cut out. For whatever reason. Oh my God, look at him. Ew. So I wish the audio didn't. They're about to go on break. The audio cut out. So I would imagine, I wonder if they return after this, though, to set a time for the voir dire. I would imagine so. And at that point in time, they might further discuss what they are allowed to talk about. So let me see here if I can find that. So this is day 22. Let's see here. Just take a quick look. Okay, on the record. The thing that makes it easier to find is that, in most trials, they put things on the record and have discussions outside the presence of the jury on a daily basis. Like that's just like normal. And we'll talk about scheduling or whatever, and it was so unusual with this trial that Judge Bev never did that. It was like just chops off the bench, right? So luckily, the times when they actually do stuff outside the presence of the jury is like few and far between. So let me just see here. It looks like, let me try day 25. I'm just taking a look. Day 26. Yeah, I don't know. Let's see here. So here's the day with Trooper Paul. I would imagine, let me do this real quick. Let me share this. I would imagine they're going to bring it up here because this is the day before the voir dire. So let me just take a look. There's Trooper Paul.
All right, Mr. Lally.
Yeah, you guys didn't expect to see him, right? So let me just look and see if there's. I do feel like they have something come up with him. Let's just see, because I'm just thinking they might mention something else regarding ARCCA. This is the day before the voir dire day. So if we see, there's Mr. Whiffen. There he is again, still on the stand. And there's Trooper Guarino, speaking of which. Text messages. Maybe at the end of the day, let's just see what's happening here. Oh my God, Lally took for freaking ever. Okay, no, still on him. Okay. Just go to the end here. And see.
Is the federal holiday, so we're not in session.
Aha.
I know there's supposed to be some.
Okay, she's talking to the jury. So they might say something. Let's just listen.
Heat wave this week. I really appreciate.
January 29th at 6:03.
I didn't mean to do that. Sorry. Okay.
All right, so please, those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Let us know. We'll see if Thursday.
All rise for the court, please. All me.
Anything?
Okay, thank you.
Okay. The court fee hasn't cut yet, so there's hope. Maybe not. Let's just give it one more second.
See you tomorrow.
Oh, see you tomorrow. Dang it. Look, so they all just went up and talked and it was just muted. They put it, okay, dang it. So the reason this is interesting is because that could have been one of the conversations where they talk about, they just went up and talked at the bench and we didn't get to hear it. See you tomorrow. Okay, so now we're going to go, I'm going to get voir dire ready here. Voir dire day. Okay. And we'll go back to the hearing, but I just wanted to get all these so that we can refer to it back because the voir dire is going to come up. Okay. Okay.
The answer. That's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview.
And that's exactly, and I wrote it down. That's exactly what we just heard Mr. Yannetti say.
Them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not
said that. We just listened to it.
Complied with your Rule 14 obligations. And the defense says, we can't, Your Honor.
And Mr. Yannetti said it emphatically like that. Maybe he did. He said he hasn't watched the trial. He said he's using the transcript. But we just listened to it. Mr. Yannetti said, we can't, Your Honor. He said it emphatically like that. He's kind of.
Your Honor said, so you can't, but you haven't. So I'm left with that. You have not complied.
So, yeah, it was a heat wave. That was back during trial summer of last year.
Transcript is this.
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed the TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request. So Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense.
That's annoying because he can watch it, right? He's like, I'm at such a disadvantage because I wasn't there and I can only, you can watch the trial. You can watch it, you know? And again, it sounds like he kind of did.
Not only the federal government, but the ARCCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolfe, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me.
Hold on. Let me back that up so I can get the date.
Back in 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolfe, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please,
I'm going to write down March 22nd, 2020. So before the trial. Okay.
is that there are conversations between the defense, Attorney Jackson, and Daniel Wolfe, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free.
Now remember, what was represented by Mr. Unity was all they have is their background and their all the only communication they've had is for their background and coordination of testimony.
To forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with the retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not.
So let's listen again.
As required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment.
So this is not an undated email. I know there are undated emails. I wrote down the date of this that he said this was March 22nd, 2024.
They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion.
Wait, I went back far enough. Okay. Actually, there you go. So it's a.
And Daniel Wolfe, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free.
Okay, this is what I wanted to get to.
What we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolfe, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolfe writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again,
hold on, June 22nd. Let me take a look here at this voir dire day. So voir dire day, I'm going to write this down. Voir dire day was on June 18th. Okay. So, and then the day that they testified was June 20th. Wait, no. No, that's not it. Hold on. I don't have the right. June 18th is the voir dire for sure. Let me just double check because these dates really, really matter. Okay, hang on. No, I think it's day 3. Yes. Okay. Here it is. Day 30. So this is on. Hang on, guys. So it is June 24th. Okay. So I'm writing these dates down and I'll go over it again. Let's make sure everybody's clear. So March 22nd was the email. That was the first emails you read, which there was nothing nefarious there or whatever. June 10th was when they discussed it, the reciprocal discovery in the hearing, and we just watched that. June 18th is the voir dire day. June 24th is the day they testify. So now, let me back this up a second here.
Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd.
Okay, so June 22nd. So this is, again, to give us, so 18th is the voir dire, 24th is the trial, so testimony. So this is 2 days before the testimony at trial.
Daniel Wolfe writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
Defender, he gave a date. I mean, I'll back it up again, but how could this be recent? Unless, I mean.
Regarding how our involvement will move forward. Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolfe writes, Alan,
It doesn't say the year, but it can't be 2025. So it has to be 2024. June 22nd, 2024. So I don't know what you mean, Fender, if you want to clarify, because this is dated in between the voir dire and the testimony at trial.
I spent some time this morning putting together a brief outline of my qualifications. Also attached my...
Unless someone's thinking that Hank Brennan like fabricated something in these emails, or I don't know, but like I don't think he would go that far. I would trust that if he gives a date, I would trust this, if the undated ones, of course, there's a question mark there, but when he gives these dates in these emails, I would assume these are accurate.
D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent.
So here's what we need to do. So again, he's not putting, okay, let me back it up.
Move forward. Daniel Wolfe writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please.
Okay, so what we're going to do now is we're going to jump to the voir dire, because what we will see is what they were told. Like what was said, and after the voir dire, were they told not to be in communication at all? So we're going to see what happens there, and because was there anything wrong about this communication before testifying, right? So let's just jump over to that. Okay, so and let's see. Oh my God, freaking Lally. There's Dr. Russell. Okay. We're going to just get the important parts out of this here.
So the other side of the court, in case now here, should the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
very loudly into my.
Whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolfe, last name spelled Wolfe.
Sir, what do you do for a living?
I am the director of accident reconstruction at a company known as ARCCA, ARCCA.
And tell us a little bit about ARCCA. If you could explain to the court what ARCCA is and what its primary mission is.
So we don't need that. We're going to get to the part where he asks the questions about, have we done this and that?
So
Da, da, da.
Of ARCCA specifically.
You know, have we pay you? Did we hire you? All that rest.
The military, Department of Defense. Have you contracted with other entities or agencies supporting accident reconstruction, but human factors as well?
Yes, sir.
Can you give me a synopsis of the professional discipline of accident reconstruction? What is accident reconstruction?
Well, I think that's a very broad topic. I look at the cases that come across my desk. You know, I've been involved with pedestrian impacts, and that could be.
The fact that he corrected that shows he didn't. It might have been an act. I don't know. He corrected that, and so I don't know. If you intentionally lie like that to the court or misrepresent something knowingly, and I mean, the sanctions, are huge for that, right? Like, depending on what it is, it could be losing your bar license. So I don't know. I don't think he would take that risk if by again, he did correct that, but I'm going to go ahead again here to where they get to the parts that matter with this. He's certified. Okay. Okay. Not that. Here we go. We're in the right place though now. Okay, here we go.
Other courts to testify as an expert in the area of accident reconstruction.
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, when you walked into court, you and I ever met face to face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCCA, with the responsibility of doing an accident reconstruction in this case, correct?
Correct.
The person to my left, the female to my left sitting here.
I want to hired you to do accident reconstruction, not hired you to testify. Hired you to do accident reconstruction, right?
You ever seen her before?
Nope.
You know who she is?
Yes.
How many times have you been qualified in other courts to testify as an expert in the area of accident reconstruction?
I think it's around 20 times to date.
In both federal and state court?
Just state court.
Multiple states?
Yes, sir.
Your analysis, conclusions, and opinions.
I'm going to back it up one more time because I want to see if the way he asked those initial questions, if that's going to differ when he goes to Dr. Rentschler, because it looks like whatever communication is potentially being had was between just him and Dr. Wolfe, maybe. So let's just see one more time. Okay.
Were you hired by the defense in this case?
No, sir.
Before this morning, when you walked into court, you and I ever met face to face?
No, sir.
When he says, were you hired by the defense? That sounds like hired to testify.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So
Wait, hold on. I missed something.
Vehicle control history and braking issues.
Yes, sir.
Have you qualified in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, when you walked into court, you and I ever met face to face?
No, sir.
In terms of the commission that you were asked to undertake.
Okay, right. So it was because of the previous sentence was specifically about doing performing the accident reconstruction, and that's why he followed it up with that. Okay.
In this case.
So hired by the defense, but again, let me back one more time just to be sure, because this matters. Okay.
A peer-reviewed article known as Collision, the International Compendium for Crash Research dealing with vehicle control history and braking issues.
Yes, sir.
Have you qualified in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before, have you qualified in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, when you walked into court, have you and I ever met face to face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCCA, with
Yeah.
responsibility of doing an accident reconstruction in this case, correct?
Correct.
The person to my left, the female to my left sitting here, you ever seen her before?
Nope.
Okay, so then it still stands. The first thing he said was, were you hired by the defense? No. I'm just thinking it through because like hired, I think hired goes beyond even like we will pay you but haven't yet. You know what I mean? Hired to me means like there's an agreement to pay, right? And that's going to come up later here in a second. But one more time here. Third party agency.
Commissioned you, or ARCCA, with responsibility of doing an accident reconstruction in this case, correct?
Correct.
The person to my left, the female to my left sitting here, you ever seen her before?
Okay.
Nope.
So then it's going to get into other things. So then we'll see if they come back around to anything about that. There's cross. Let's see if anything comes out on cross about it.
Sort of provided, let's say, sort of technical review of your work and luminescence, things like that. You didn't do any of those things. Thank you.
Okay.
Good morning, sir.
Good morning.
Now, you went through a list of about 14 things that are contained within your report that your firm or your agency was provided with that you reviewed, correct?
That is correct.
Did you specifically review all 14 of those things, or was that done as sort of a team?
Yes, I looked through all of the documents.
Do you personally look at all 14 of those items that are listed within the report?
Yes, sir.
And you indicate that it was your opinions or what you did in this case. That was you were asked to answer specific questions, correct?
Okay.
Yes.
It wasn't like you were just tasked with, hey, here's some facts, go do or take a look at a crash reconstruction or read a crash reconstruction. You were asked very specific questions and you tried to answer them the best you could, correct?
I don't know that there were specific questions. I think
I'm going to use the text up here to try to find the part where if he asks any questions about, who paid him, who hired him, what, oh, there it is. There it is.
so as a part of the engagement with the entity that ultimately retained us in this, due to the confidentiality of it, only those who had access to the material to the file were allowed to review it and discuss it. And essentially, Scott Klein served as kind of another reconstruction expert to essentially bounce ideas off of and help with the review.
Entity. So interesting, right? So we heard the word retain in one of those emails. So that's FBI or DOJ. Opinions. Dr. Rentschler.
And I apologize for this. I'm just unaware. Is it Mr. Wolfe or Dr. Wolfe?
Dr. Wolfe is fine.
Oh my God, law.
So, Dr. Wolfe, when you say that you were asked specifically whether or not the evidence, the limited scope that you were provided was consistent with a pedestrian collision, were you asked sort of in general terms as far as any type of pedestrian collision, or were you asked?
Getting to the opinion. Oh, he's all set. So Lally doesn't even ask him anything about, more specifically about the engagement and all that, the stuff that, or the discovery. Okay, so there we go. So Lally didn't even go there. So now we're going to get to Dr. Rentschler. And again, I'm curious to see if there's going to be anything different.
The truth, the whole truth, and nothing but the truth, so help you God.
I do.
Last name for the record. Sir, what do you do for a living?
In Pittsburgh, Pennsylvania. I am a vice president. So ARCCA is a engineer of vehicles, as well as research and development for government.
And I'm just going to jump ahead to get to where he asks those similar questions. NHL, I gotta remember that. Slip and fall, human factors. Oh, wow. He didn't even ask him, and it didn't even come up. Interesting. Oh, wait, no, sorry, just kidding. That's still him. So it's not. Okay. He just said how many times he's testified. Okay.
Yes. For the purposes of what here, Your Honor, I would ask that this document be marked.
Sure.
Thank you. Have you ever testified in criminal court as an expert in biomechanical engineering?
I have, yes.
How recently have you testified in criminal court?
Well, actually, I've testified twice. The end of May, I think May 31st, I testified in McKean County, Pennsylvania. For the prosecution, it was a case where the defendant was accused of beating his girlfriend to death and basically said that she fell down the steps. So my testimony involved determining how her injuries occurred and that they were entirely inconsistent with what would have happened during a stair fall.
What about another case?
And then about a week after that, around June 6th or 7th, I testified in Cambria County, Pennsylvania, again for the prosecution for another homicide case where the defendant was accused of essentially beating his wife to death and then said that she actually fell backwards and struck her head, caused a skull fracture on the side of the sink. So my testimony, again, pertained to looking at the injury mechanisms and determining that his story of her falling back and striking her head on the sink is inconsistent with the injuries and the type of force that would have been exerted in that case.
In both of those murder cases, you were hired or retained by the prosecution in the case, not by the defense, correct?
That's correct, yes, sir.
Your opinions in furtherance of the prosecution's case in chief, not the defense case in chief, correct?
That's correct, yes.
With regard to this case, you were asked to look at several items. We've already gone over those in other testimonies, so I won't belabor that. You were asked to look at several items, correct?
I was, yes.
And ultimately, based on that series of information, that universe of information that you were provided, see if you could come to an opinion and conclusion concerning the incident before the court now, correct?
That's right. See if I could determine what happened, how the injuries occurred, and the events leading up to and during that process.
Without going into your conclusions and opinions, were you able to come to conclusions and opinions to a reasonable degree of scientific certainty?
I was, yes, sir.
You were not hired by the defense, or anybody on the defense side in this case, correct?
That's correct. I was not.
You were not consulted with or hired by the Commonwealth either.
That's correct. I was not.
It was a completely independent agency, is that right?
That is correct. Yes, sir.
Before this morning, have you and I ever met?
No, sir.
And we've never talked about, you and I have never talked about the substance of your opinion and conclusion, correct?
We have not. That's correct.
You did reduce those opinions and conclusions in conjunction with your team to a report, is that right?
I did, yes, sir.
And your understanding is that report was made available both to the defense and the Commonwealth in this case, is that right?
Yes, sir. That's correct.
I have nothing further.
Okay, Mr. Lally.
See if Lally doesn't
Thank
even
you.
cross. Confidentiality. I doubt he will because he didn't with Dr. Wolfe. So let's go to.
Discuss the substance of my opinions or my report with.
Now we're going to see what is said about what they have to do. Prior to testimony, this matters big time.
Into the ultimate opinions and the basis for that opinion, but I'll hear you on your motion.
And again, I'm gonna, if it's Dr. Russell or anything, I'm gonna skip that and get just to the ARCCA.
So I think very simply what the Commonwealth had been seeking for the most part was covered today.
Okay. All right. I have some questions as to the scope of the testimony of the witnesses.
Hang on, I want to see what he said that about because I was. Interesting. Hold on. He's saying, is he saying that he's satisfied? Hold on.
Your Honor, what essentially what Commonwealth was seeking and had been seeking was just in reference to that, as far as who did what and who was responsible for what and what were the items reviewed and is that the totality of it. there's a date on the report. I don't know if that was a date as far as when it was filed, when it was opinion was rendered, when that was provided, what was provided to them in the course of their analysis. So I think very simply what the Commonwealth had been seeking for the most part was covered today.
Okay.
I remember that. So what he's saying, remember how there was like 3 names mentioned and then they were like, they're only going to call 2. Part of what, so he's saying the issue that they had and what they were wanting for discovery was who did what, because it was kind of unclear. And that's what he's just saying. And so he's saying, yeah, we're satisfied for the most part. Interesting.
All right. I have some questions as to the scope of the testimony of the witnesses.
We can skip past the scope because we've all been there and heard that, and that's not the thing that's an issue here. It's triple Paul. Oh my God. Blunt force trauma. Okay.
Quickly, we could have had the jury here, but I'm sure you all could use the afternoon to prepare. All right, Mr. Lally, let me know Thursday if you need.
Back it up just a second, just because I feel like she might give them a final thing that they have to don't do this or don't do that right prior to the trial testimony.
It's an opinion at all, to be honest with you.
All right, I'll take a look at this more closely, give you a decision Thursday. All right, I did not expect it to go this quickly. We could have had the jury here, but I'm sure you all could use the afternoon to prepare. All right, Mr. Lally, let me know Thursday if you need. Are you ready to go forward at least with your case on Thursday?
Oh, yes, sure.
Let me know Thursday if you need additional time. If I let these witnesses, if I let Dr. Russell testify, how that impacts our schedule. Okay.
Absolutely.
All right. But I don't want that to be a concern of yours, how it impacts the schedule. That's my concern. I just need to know. All right. So anything else?
So it sounds like they're going to say something else about it on the next day of trial. So there might be some follow-up here. Let me just see. And that would be on June 25th. Let me just see here. Okay. So that would be day 28. I think I checked this, but let me just double check. Because it sounds, she said, let me know, right? And again, the times that she spoke with counsel on stuff was so, outside the presence, like there wasn't much of this. So let's just see. No sound yet. If they're gonna put something on the record, they'll do it at the beginning of the day or at the end of the day or like at a break or whatever. So I'll put the subtitles on and then I'll be able to see. When the sound comes on. Okay, let me just do it this way. Oh yeah, we have a good while. So there she is. Hold on. There she's on the record there. I mean, it showed her speaking in the mic. Is there just no sound? Is she talking? And then, dude, I hate it. Is that what's happening? Are we just not going to hear this? Because it showed her talking. Oh, here we go. Cool.
So moving on to the voir dire motion the other day.
Sweet. We did it, guys. Here we go. I'm going to pull my banner down. This is the follow-up. Okay. Good.
Or voir dire hearing in response to the Commonwealth's renewed motion for reciprocal discovery and motion to exclude defendant's expert, Dr. Marie Russell. So the Commonwealth was alleging violations of Rule 14's reciprocal discovery requirement, and the Commonwealth asked for exclusion of Dr. Russell. I did find and do find that there was a violation of the reciprocal discovery obligations of the defendants. I was looking for a remedy. You called it a sanction, Mr. Jackson, but I called it a remedy. And I did tell counsel, as you know, at sidebar a couple of times, at least last week, that I did not want to exclude the testimony if I did not have to. So we had the voir dire, and I'm satisfied that the voir dire provided the Commonwealth the information that the defense should have provided the Commonwealth. So I'm going to allow Dr. Russell to testify, but her testimony is very limited, and I think you even sort of acknowledged it the other on John O'Keefe's arm. DR doc specialist as to what the injuries are beyond the scope of which she can testify. The second part of the Commonwealth's motion.
She said she was satisfied, guys.
Commonwealth argued that they were not provided reciprocal discovery regarding the biomechanical engineers and others, but specifically.
I'm clear. It sounds like when she was saying they were satisfied, that might have been as it pertains to Dr. Russell. So let's see what happens.
ARCCA, Dr. Wolfe, and Dr. Rentschler. And I do find, though, I understand why the defense didn't respond, but it is a violation of Rule 14. So we had this voir dire. The Commonwealth was looking to see what each person did, their independent opinion, what their testimony would be, and whether they were qualified to render the opinions that they qualified. So from what I heard the other day, Dr. Wolfe can testify to what his involvement. Dr. Rentschler, though, I have some concerns. It's clear to me that in Massachusetts, biomechanical engineers.
Right. We can. Oh, this is the part. Well, we all know what this part is important, right? Everybody's familiar with that, but we want to get to the part. Oh, okay.
I'm going to reserve ruling on the rest of his testimony. There are certain things he can testify, and I'll hear you again before he testifies next week. Let's just proceed with the trial today. So, okay, so those are my rulings. Are they clear, Mr. Jackson?
So it sounds like when she's saying we're going to talk again before they testify, it sounds like she's saying, though, it would pertain to Dr. Rentschler and what all he can testify to.
Are they clear, Mr. Lally?
Yes, Your Honor.
Okay. All right. So are they ready to come in? Thank you.
Okay. So there's the follow-up on that. So nothing about, it sounds like issues resolved. Nothing else there about whatever. Okay. So now let's go back to the hearing.
Feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then have provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth.
Yeah, but I don't see why this is a problem, because they represented that they didn't have anything. See, this is the thing. They said they didn't have anything for background and coordination of testimony, but that was before the voir dire, right? We just watched the voir dire. We watched the follow-up to the voir dire, and there was nothing that said that in between the voir dire and trial that they couldn't communicate, right?
What follows from this outline is then the outline with remarks from this independent expert who knows nobody.
Have a great day.
So we see in the margins in the notes, this fair-minded objective witness says,
Great day off.
so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a
back this up and just make sure. Does he give a date on this one, though?
information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then have provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, Not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated.
Okay, that's the not dated one.
The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusion.
That's the not dated one.
Of ARCCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them.
And what's really funny is what I heard about this. Everybody seems to think that that was in the email. That I guarantee that no way. That look, he's not reading when he says it. That is Mr. Brennan adding that. I guarantee you. I guarantee that's Mr. Brennan adding that. I guarantee you. I fucking guarantee you.
Pretty important stuff in this case.
And the reason I say that also is because when I was listening to this, the snippet that I heard earlier, I was like, wait. I remember that question coming up at trial because I remember being like, well, of course, like, okay, hold on. This whole thing about the pedestrians at night, right?
Ability work, your cases frequently involve pedestrians. Yes.
And I remembered hearing this question at trial. So let's take a look. And that's also, again, why the shush, don't tell him, right, is Mr. Brennan adding that in. And also, shouldn't he know that this came up at trial? Because shouldn't he have read the transcript or watched it? But he says he's not. So this to me is trying to, it's not lying, right? But it's trying to mischaracterize something by not presenting all of the information. However, that is normal, right? It's an adversarial system. And I guarantee you when the defense gets their chance, they're going to be like, we didn't say that part, that was added in. And also like this, this did come out at trial. And then I'm sure they're going to say the same thing, which is, and Mr. Brennan, who has read the transcripts, and he should know that this did come in at trial. So like this whole thing is in other words, this whole argument that he just was making about the shush, don't tell him, and this whole thing is moot completely. That you can just delete all this in terms of potential issues. So now I'm going to go to where he testifies, and then, okay.
Continue to take courses subsequent to graduating.
Do you also hold any accreditations in terms of accident reconstruction?
Yes, I'm accredited by an organization known as.
Okay, so we can skip past the accreditations. Oh, we need to get to this part too.
Experience in your career, have you reconstructed or attempted to reconstruct?
How many times has he testified?
I don't actively track that. If I had to estimate at this point in my career, it'd probably well over 1,000.
And how many of those 1,000, I know you'd have a number specific, but how many of those 1,000 would you say involved pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having difficult.
Let's listen to this again. I'm going to add this banner. Here we go. So see what I'm saying, guys? Hold on. Sorry for that terrible pause, Dr. Wolfe.
If I had to estimate at this point in my career, it'd probably well over 1,000.
And how many of those 1,000, I know you'd have a number specific, but how many of those 1,000 would you say involved pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
Done testing or research as it relates to the kinematics and the interaction between pedestrians and vehicles.
Oh my God, the kinematics. So while we're here, let me go to the part where he says how many times he's testified or whatever. Peer reviewed. You just see here. Are they sidebar? What is happening? What are they doing? Was there an objection? I'm confused. Hang on.
So we were able to determine that those triggers, the sudden braking event is triggered when a driver, or I should say the vehicle, reaches.
May we approach?
Sure. There was an objection. So, okay. I'm just trying to find the part where he says how many times he's testified as an expert. And let me see here. It might have been before the part we just
play between objects.
Association for Professional Accident Reconstructionists, the Optical Society of America, and also the. If I had to estimate at this point in my career, it'd probably be well over 1,000.
And how many of those 1,000, I know you'd have a number specific, but how many of those 1,000 would you say involved pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having difficult.
Further.
As you to perform the duties that you just described for the jury.
Back in 2012, I received a Bachelor of Science core engineering degree.
What additional training or experience?
Any accreditations? Because I just know there's going to be a thing that comes up about how many times he's
on map scenes, evidence from photographs, things of that nature.
Absolutely. So photogrammetry is the science of extracting information.
Okay. Okay, so that confirms that then it's after this part, actually, that he gives that number.
So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours.
It's going to be
ARCCA for our testing. So if we want to have an understanding that an occupant in a vehicle, the forces that they might experience, or for any matter, again, if it's an instance where you have something that ends up falling on someone's head and you want to have an understanding of the forces involved in that, we perform testing with hybrid dummies.
Have you ever authored any peer-reviewed papers in the field of physics?
And optics.
Is that called Toyota specific to dealing with vehicles?
The various triggers we were able to.
So this is he's gonna get to the part about how many times have you testified here. Oh my God, there's another objection. What the fuck is wrong with Lally, dude? Oh my God. Wow, weird. Weird. Oh, actually, we need to hear this part too anyway. Okay. Here we go.
Now you're.
Yes, you can move on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction. Is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolfe, and your consultation, you and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Ms. Little.
No.
Mr. Unetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense. Is that right?
Correct.
And not connected in any way to the Commonwealth. Is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized a report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You'd never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
And you don't work for us?
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Okay, now that part. So let me back it up. Okay.
goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter
The reason I think that's important is because I know that there's the thought, some people I saw talking about like potentially like, okay, well, what if the workaround is like, well, they haven't been paid yet, but they will be in the future. Well, that means you've been hired. So to me, the difference, in terms of the semantics of it, hired is like you could have been engaged into to perform some sort of work, and you could have also been paid. But it's also common, right? You can be hired and you can get paid after your work or whatever. There's an arrangement. It doesn't mean you've been paid yet. So the fact that they say paid.
That is correct.
goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense,
You have not paid us anything, no.
and you don't work for us.
That's correct.
As a matter of fact,
That to me goes to we didn't hire you. So, and I'm wondering if, I guess Mr. Jackson could be thinking that hired because okay. Again, where I think it matters is like they were hired to do the accident reconstruction by the DOJ, right? They were paid to do the accident reconstruction by the DOJ. The part where it gets a little bit confusing is like testifying at trial is a separate thing. So when he's asking these questions, I guess, maybe he was thinking of it, in the way, and maybe this will be what he says, is that he was thinking of it as in, like when he's saying you don't work for us or you weren't hired by us, he's like referencing for doing the actual work. What am I getting at? What I'm getting at is potentially, is there a way that when we get to the part about the expenses, is there a way that all of it can be true? And essentially that there was money, given as, for expenses and as a per diem or whatever, travel, what have you, right? And that they hadn't received that yet. And that, when he says hired, maybe he's referencing hired because hired to actually perform the reconstruction, or maybe he's thinking hired. Maybe the way he's saying hired is he's saying hired as in getting paid on top of just your travel expenses, right? Again, this is going to be one of those things where they can argue over the semantics of it. What does hired mean? What does, I think everyone knows that if somebody says you haven't been paid yet, it still means you could be paid. I think that being hired is going to be maybe part of this. Because to me, I would say that it feels to me like if we still don't know if the DOJ paid them for their testimony, right? We don't know that. I don't see why they would, because this is completely separate, right? We need a lot more information. I'm thinking about this. We need a lot more information. But basically, okay, let's just say that they were being paid for their time, right? And they're just coming to testify for their time. Let's say that they were paid by the DOJ for that. And then let's say, this is hypothetical, right? That their travel expenses and shit were covered by the defense. To me, I would still say, yes, they weren't hired, because I would think of it as, okay, you're being hired by the DOJ as in they're paying for your actual services, right? That's how this is just how I would understand it. And, we went back and watched everything that was on the record, and they weren't ever asked, no one asked the defense or the ARCCA dudes anything more specific as to the arrangement, the financial arrangement. There was nothing. So it wasn't like, what do you mean by hired? That just never came up. And so it seems like they were more concerned with the bias of I guess they were really more concerned with what they were going to testify to and their opinions and stuff. And everyone seemed to be on the same page. They're independent. my feeling about what happened at the time, right, was like everybody was on the same page. And by everybody, I mean the Commonwealth, Judge Bev, ARCCA dudes, and the defense. Everybody was on the same page that they weren't being paid or hired by the defense. And again, now those words are mattering more, but like essentially they were being paid, they were working for the government, and now they're here, right? And no one seemed to inquire more into it, right? So Carlos, as a lawyer, never asked a question they don't already know the answer to. Right. No, right. Well, what were you referencing though when you said that? Because that was a couple minutes ago. I just now saw it. I'm not sure what you were referencing when you said that, because which lawyer, which question. Okay. But again, with the hypothetical, so let's just say that they weren't being paid by the DOJ for their time and their services, right? Then even if they've said, okay, we're going to do it for free, but then the defense said, we'll cover your expenses and whatever. I think that's where it gets trickier, right? Because does that count as being hired? And in a way, if you think about the difference of like the word engaged, right? They were engaged by the DOJ initially, right? But like in terms of coming to testify, the DOJ wouldn't have anything to do with this. I wouldn't think. And so, they were at, you know what I mean? So Carla, so you're thinking that he was hired as in agreed to be paid, but hadn't been paid yet. Is that what you're thinking? So, but that's why I've been going through all of it and being really careful with the words, because the wording that was used with the way it was worded in voir dire, he asked it a little bit differently today, but the way it was worded in voir dire, he said, you weren't hired by the defense. That I broke that down a few minutes ago, I think before you got here. On voir dire day, he said, you weren't hired by the defense. And they said, no, not hired by the defense. So that's where I think it's easy to be like, okay, yeah, again, that's normal if you're like, yeah, we are hired, but we haven't been paid yet. But the problem is, like he said, on voir dire day, you weren't hired. And they said, no, we weren't hired. So now we have that's where I think the issue can be there. So he phrases it a little bit differently. Let me back it up, actually. He just says, like, you don't work for us, right? But again, to me, work for us and hired are the same, because again, you can work for somebody and not be paid yet. So I think he's just trying not to be redundant. Like, he's just changing it up. In the voir dire, he said, you weren't hired by us. And they said, no. And he said, here, you don't work for us. They said, no, right? So
Opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
And you don't work for us?
That's correct.
Yeah, that's synonymous with hired. And again, when he asked us in voir dire, he said hired.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Now, again, I think that these questions are carefully worded. He says, I've never asked you specific questions. Well, okay, we're going to go back here in a second. We're going to go back to what Mr. Brennan is saying. But my thought is, like, he didn't ask specific questions about the testing, but Dr. Wolfe just provided him a sample of what he could testify to, and those are different. But also, they didn't get into any specifics at all. Like, they didn't in the email that we know of, and they didn't in voir dire. It was really not, it wasn't very specific, right? Because otherwise, when he says this, right? Hold on. Because technically, otherwise it would still count the voir dire.
And you don't work for us?
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
So, like, in other words, even what they said at voir dire didn't count as specific.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides?
In terms of them reaching out?
Correct.
Yes,
And I called you ultimately after receiving your report, asked if you join us and testify, correct?
that is correct.
Join us.
Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case, as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe.
And what was your focus? If he's talking about the injuries to Mr. O'Keefe, what was your focus in your reconstruction and your analysis?
Where is the? I haven't seen him ask yet how many times he's testified. Maybe it's still coming. Okay, yeah, it's still coming. Okay. Okay, I think it's coming up here.
Conclusions based on scientific certainty.
Yes.
Did you review scene photographs of the alleged incident?
Mhm. So from those photographs, I was able to identify pieces of chrome and
That was,
well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically, when I go out and do an inspection, especially of a fresh incident, let's say I've got a debris field or I've got tire marks, what I like to do is kind of step into the scene, if you will, where you take global perspective shots and then you step into a specific piece of evidence so that you can, at a later point in time, identify where the
So he still hasn't asked the question. It's like unclear as to like if they're still in the part of like offering them as an expert. I haven't seen that happen already, but it seems like they're getting into more specifics. So, okay, no, there he's describing. Interesting. I don't know. I did not see the part where it's like offering them as an expert or like the questions about how many times did you testify? Have you testified before?
photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus 570.
data that you were provided, were you able to satisfactorily, to your mind, satisfactorily engage in the consultation that you were hired to do?
Might be.
Yes.
And come up with some opinions and conclusions based on scientific certainty?
Yes.
Did you review scene photographs of the alleged incident?
Yes, sir.
What information were you able to glean or gather from your review of the photographs, from the scene specifically?
So from those photographs, I was able to identify there was fragments of transparent red, clear plastic. There also appeared to be pieces of chrome and black plastic. I also observed what appeared to be glass fragments along with a black drinking straw.
Did you also review some videos?
Yes.
That was out at the scene, maybe a leaf blower?
Correct. It appeared to be daytime. Yes.
Okay. What did you note about the photography at the scene of the items that were being photographed?
Well, I think one thing that comes to mind is it was a little bit difficult to follow the evidence, so to speak. So typically,
I didn't go back far enough. Okay, hold on. Here.
Testing before today.
that is
Okay, let's see what happens here.
1,000.
Oops.
I know you'd have a number specific, but how many of those 1,000 would you say involved pedestrians as well?
several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
You've done testing or research as it relates to the kinematics and the interaction between pedestrians and vehicles.
Go back a little
Absolutely.
further here. See.
As you to perform the duties that you've just described for the jury.
Back in 2012, I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses while at JMU included courses in physics, statics, dynamics, kinematics, material science, along with your other engineering sciences. Subsequent to my undergraduate in electrical
training or experience.
Certainly. So courses subsequent to graduation known as ACTA. Yes, sir.
Is that to determine vehicle crash incidents or the circumstances surrounding them based on
Extracting information, seeing the object or inspect.
to your satisfaction?
No, not at all. And quite frankly, to be honest with you, in my world in civil litigation, oftentimes by the time a case comes across my desk, it's going to be a long shot.
Doctor, are you a member of any
I'm also and also
constructed or attempted to reconstruct? You or your team members?
I don't actively track that. If I had to estimate at this point in my career, it'd probably be well over 1,000.
So I'm not seeing him ask the question, how many times have you testified as an expert? Maybe he doesn't ask him. Maybe he just doesn't ask him. That might be what it is. Because that's going to come up. So now what I want to do is I want to go and see what, if there's anything on, I want to go to Dr. Rentschler and see how he handles those questions. There's cross, let's see here. And see if there's anything different.
Hey. As working for ARCCA, first of all.
I've been with ARCCA for about 16 and a half years now.
You indicated that you're the director of
Minor and biomedical. And then
Kinematics.
it's really looking at the motion and the response of the body.
Additional training.
Auto detection devices.
Your specialty, is that right?
You know, we use traditional pieces of steel. How much force does it take? And determine what the prognosis is. As a biomechanical engineer, I look at that injury from a different direction. Here's the injury. What is injury? And not only how's it produced, but ultimately our hope is to mitigate and prevent injuries from occurring.
Not diagnosing anybody. He's not a doctor. Okay. Okay, here we go.
And conclusions, including the testing and methodology that went behind those opinions and conclusions.
We did, yes.
You were not hired by the defense in this case, correct?
No, we were not.
You were not hired by the...
He said hired. Look. He said hired. So that, in other words,
about your
why
and conclusions, including the testing and methodology.
Okay. So my point is that he could have said hired to Dr. Wolfe because he's saying hired here. So that's just it. In other words, I don't think that the Commonwealth is saying that only one of the two of them was paid or hired by the defense, right? It's they're ARCCA dudes, right? They're like a group, right? I mean, so anyway, here, and I don't know that anyone double checked on this because it was Dr. Wolfe brought up in the emails, but it doesn't matter. This is he's asking the question about being hired.
Went behind those opinions and conclusions.
We did, yes.
You were not hired by the defense in this case, correct?
No, we were not.
You were not hired by the Commonwealth in this case.
That's correct. We were not.
When you started your analysis, you didn't know who we were. You did not know who the Commonwealth was.
That's correct.
You never heard of the Karen Reed case.
I had not, no, sir.
So again, the problem here is that if it's supposed to be, again, I think you can quibble over what hired means, but if it's supposed to be representing that, well, we haven't paid you yet, but we're going to, and that's the difference. That's not going to be helpful here, right? Because he's saying they're not hired, right? So I think you have to go a different route again, like maybe the way Jackson is thinking of it is like hired as in paid for your services, right? For your time. But again, that's where they're going to have to parse their words over that when they come back next week about what does hired mean. Like, for example, if what Mr. Jackson meant by hired, now this wasn't explained out loud at the time, but if what he meant was paid for your services or your time above and beyond, two things have to be met for that, right? In his mind, maybe, right? Which is paid for your services and your time, A, above what just cost for like travel expenses, and B, hasn't been paid yet. If you go with that, then when he says, were you hired by the defense or the Commonwealth, they can say no. And Alan Jackson could still say, yeah, that's still true, right? As in, we hadn't paid them yet, and we didn't intend to pay them for their time or their services. We only intended to pay them for their travel expenses. You see what I mean? That's like one potential way I could see this being talked about. But we need to jump back over to hear what else Mr. Brennan says now that we have heard that. Okay, so now we're back to.
Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors result in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
Again. So that Brennan, I guarantee you, Brennan added that. Why? Because he did say that. He did say that at trial. So this is Brennan misrepresenting this. Because if you just hear this and you think, oh, wow, he should have said that. Again, it's not, I mean, I don't think it's that big of a deal because of the fact that it's like obvious you're going to have more accidents at night. But still, regardless, it's not even the case anyway. Like, to me, the bigger deal here is that Brennan is misrepresenting it. So,
have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
And so I tried to look for it and find it, and it looks like the question just wasn't asked. But regardless, it means that it wasn't misrepresented by, like, in other words, that's not even that big of an issue anyway, right? It's like it was just an accident. It's not like a huge difference, and it was never put before a jury. So,
and then
again, that's Brennan exaggerating and trying to make a mountain out of a molehill with that one.
A bill from ARCCA to the defense for $23,925.
So, of all the issues that he's raised the bit about the turning over of the discovery. I would say that's a non-issue because when you looked at the timing of it, and then we went back and looked at the hearings that were had prior to the voir dire day, and everybody was satisfied. Okay, everybody was satisfied. The Commonwealth was satisfied. Judge Cannoni was satisfied. Okay, so that's moot point. Then when you looked at the thing about the asking about what was it? Oh, right. The one where it seemed like maybe they were talking about stuff that had to do with actual testimony or stuff. You know, what was it? The D&T and all that. Would you like me to testify this? That was an undated email. So right at this juncture, I'm not going to, I think we can table that. Right. And then we heard Mr. Yannetti represent in the very first time that the ARCCA dudes were mentioned on the record. All we've had for communication is their background and coordination of training. Well, that was before voir dire day, right? So even if you say, okay, and the other emails that are undated, like were between voir dire and trial, that's fine because when it was represented that they all had only done background and coordination of training, that was before voir dire, and that was correct, okay? And the other communications, I wrote down the dates of the emails, and so it was June 22nd, okay? And that's in between. June 18th is voir dire day. June 22nd is when they had that email. And June 24th is the testimony at trial. So it was after voir dire. So that was not misrepresented. And there was never, again, we looked at it, unless it was off the record, there was never any talk at the voir dire day or after of Judge Cannoni saying, don't even have any correspondence. Like there wasn't any of that. So I don't see any problem with what went on after voir dire and between trial testimony. And then the part about the lighting was a moot point completely because he went and testified to it anyway at trial. And then the part about the number of times testifying, I think is just, again, trying to whatever. The thing that I think is the biggest issue here potentially could be the money. Now, why is that? Because even if they were paid afterwards, right, for their expense, regardless of if it even was for expenses or whatever, right, it doesn't even matter. Being paid after, I don't think the concern here, the bigger concern is bias. I think the bigger concern is not turning it over. I think it's discovery because this needed to be turned over if it was provided. If there was any money paid by the defense, even if it was just for flight, whatever, doesn't matter. You have to turn that over to the Commonwealth. Like you have to. Like you can't just. You know what it's like? It'd be like trying to do like under the table, like with taxes and stuff. It'd be like that, right? Where it's like No, you have to report it. It's like, think of it like that, right? It just has to be reported. Like this to me, I think is the biggest deal. And again, Hank Brennan might try to represent it goes to bias or whatever. Let's just see what else happens here. But what I wanted to do was go through each of the issues he's raised so far and say that all of them I think are moot unless we get further information. But I think this last one is the biggest issue. Well,
That's
the
not
only
true.
issue actually.
That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases.
Hold on, let me go back a little bit. Yeah, he doesn't, dude. This is so funny. He just says a bill for that money. He doesn't say who it's, dude.
I don't know if it was ever cleared up.
Hold on.
And then a bill from ARCCA to the defense for $23,925.
A bill. Now, also, I will note that doesn't say it's been paid. I don't know if anyone's noticed that. It doesn't say a check from the defense to ARCCA. It doesn't say, in other words, it says a bill. And the thing that matters about that, right, is because, and he also didn't say when it's from. He didn't say when this is from. It's entirely possible that this bill to the defense from ARCCA was from earlier, right? Before it was clarified that they were being retained by the DOJ. It could be that, in other words, if you're the ARCCA company, right, specifically may not have known the specifics about this, that, you know what I mean? So that they could have sent it and then afterwards, oh, wait, no, sorry, you need to send that to the DOJ. I mean, you know what I mean? The fact, because in other words, it's just a bill. We don't know who paid it and there's no date. So that's what's crucial there. So I don't know where the whole expenses and stuff came from because I don't think we have anything that says that. Like, I mean, if indeed it was paid by the defense, and if indeed the date is after the trial or whatever, well, then you can get into that. But I don't even think you need to go there. Right now, we don't know when this is from, and we don't know who, if anyone, paid it. Just to quote Lally, we don't know who, if anyone, paid it. Because think of a bill, it's like an invoice, right? So that it can happen where the invoice gets sent to the wrong people, because some companies do that automatically, right? They send an automatic invoice and it's like, wait, hang on, they didn't know the specific circumstances, right? It doesn't say anybody got paid. It's just a bill and there's no date. But the thing that is so funny here is watch how many times Hank Brennan stacks loudly his papers.
That's not trample. That's not trial by ambush.
One.
That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit.
Literally, watch what he does. He stacks them. He puts the paperclip on, then he takes the paperclip off. This is insanity. Like, what the fuck are you doing? Watch. Stack one.
That's getting duped. So
I
didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit.
Right there.
I know how it works. Sometimes parties pick sides.
Stack number 3.
It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening. A federal
This part just I just annoys the fuck out of me, man. The illusions and the ghosts. Like, what are you even talking about? This word, it's word fucking salad, man.
Investigation and this person, and then this happens. I don't care if the ARCCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCCA.
All right, I'm going to take a recess before this.
So he's not saying anything about binds. He's just saying, he didn't say anything about bias, did he? Let me back it up one more time. It's so distracting with the paper stacking. I mean, I understand that normally it goes to bias, but that's not what he's saying. And he's saying turning over of the discovery. So I still think it's a discovery thing. And the reason why the discovery matters, right, is because it can go to bias. But regardless, even before you get that far, like I said, the important thing is, like, they should have turned that over, even if it was after the fact, right? For example, like, even if, okay, so if that money, again, we don't know who paid it, we don't know what date that's from. But if, let's just say that 2 weeks ago, right? Let's just say 2 weeks ago, the defense paid them that money, and let's say it's for upcoming trial, right? And I don't know the specifics of when they had their deadlines. I'm sure I could pull that up on the scheduling order, but okay, let's change that up. Let's say a month ago, okay? Let's say a month ago, the defense paid them that some amount of money, $23,900, and it's for the upcoming trial, okay? And let's just say that their discovery deadline had passed or something, right? And they didn't that's still a problem, right? You see what I mean? So you have to turn the stuff over. And the bias would only matter in certain circumstances. The discovery matters no matter what, right? So in other words, it could either be something related to discovery and bias or just discovery, but regardless, it's discovery. So that's, I guess, kind of what I'm saying. And he's not saying bias. I think he's just saying discovery, because that's the first thing you have to get to. You can't really say anything about bias until again, we don't know, and apparently he doesn't know when that money was from, or if it was ever paid, or who it was paid by. So that's where the discovery matters. You need to have that information before then you can go any further, right?
Posts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. I don't care if the ARCCA witnesses testify at trial.
Now, I remember he did make a snarky comment about this fair, unbiased witness earlier, right? But that was one of those things that's just like annoying, and it's like for the media, because it doesn't seem like that's actually part of his argument here. Again, it's a discovery thing.
I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce a discovery, I'd welcome ARCCA.
And that's the thing, is like, even if it's found that money had nothing to do with anything, like, we just don't know, right? That money might not. It might be that the Commonwealth says, yeah, we figure out what this money's for and when it's from and who paid, blah, blah, and it's clear that it had nothing to do with bias, and maybe it was for the upcoming trial or whatever the case may be, right? All those things can be true. But if it was supposed to be turned over and it wasn't, it's still a discovery violation. The difference is that, just depending on what it is, the outcome might be different, right? But they have to turn over discovery.
All right, I'm going to take a recess before the response.
All right, please.
Now, if that bill, right, was and it was an accidental bill to the defense, and it was supposed to go to the DOJ, and then let's say that somebody else paid it or whatever, then I don't know that would then I would say that then even the discovery issue would be moot, right? Because it's like, well, it doesn't actually involve them. But okay, so she's gonna take her break. Let's go ahead. I think the important thing is just literally is in terms of the money, he's talking about other stuff, and then and then we get a bill for $23,900. I mean, the part that is so shocking to me is like, he doesn't say, he says a bill to the defense. ARCCA bills the defense, right? Nothing, no date, no reason, no who paid it. No, we don't even know if it was paid. Like, that to me is crazy, because how can you make such a big deal about something like that when you have no information? That's crazy to me. So. Right, exactly. And the thing is like, he doesn't know. Like, all he has is what we just heard, right? And so, in other words, without the discovery, you can't fault him either. If he doesn't have the discovery that says if the bill was ever paid, then you can't fault him, right? Which is why, again, this is about the discovery. Now, if he knew that the bill was never paid, then he would be misrepresenting something. But if he knew the bill was never paid, then it means he already has the discovery. So you see what I mean? But yeah, I agree. Like 100%. Well, if the bill was never paid, he doesn't have a leg to stand on as it pertains to anything with like bias or whatever. I think that the point is like, the discovery needs to be turned over. And if the bill was paid, if the bill was never paid by the defense and it was paid by somebody else entirely, then yeah, I would agree. He has no leg to stand on, because I don't think that's part of the discovery that would be, you know what I mean? Unless there's something that shows, unless there's some communication from the defense back to ARCCA saying, hey, you sent this to the wrong people, blah, blah. But then it would be in the defense's best interest to turn that over. Maybe they just didn't, I don't know. Because any communications that are between ARCCA and like any other entity, say the DOJ, that's not the defense's job. That's not their, you know what I mean? They have to seek that from the parties that are involved there. As you guys know, that's the TUI request. But we're gonna hear more about that here in a second.
Cell phone off, put it away.
I mean, and that's what I'm kind of hoping. I'm hoping that it was an invoice that was sent incorrectly to the defense, and it was never paid by the defense, and maybe it was paid by the DOJ or whatever, right? Or that the date, we just don't know. It could have been for the upcoming trial. And as long as it wasn't, as long as the defense's discovery deadlines aren't over, then this could be, then literally every single one of Hank Brennan's complaints could be completely moot, all of them. So let's see what she says, and I'm going to take a look and see if I can pull up the scheduling order and see where their deadline was. But the thing is that is so crazy of all of this is how mad Bev Canoni is, because you know what? That break that they took was really long, like 30 minutes. And everything that I just looked at when I said, here's the list of his issues, and you can go through, and it's like, okay, maybe we need a date on this. We need a date on that. There's like two things we need a date on. One was one of the particular correspondences we needed a date for. We need a date on the money. But everything else is completely moot. And all she had to do is look at the transcripts for the voir dire day and the trial testimony day. And like, in other words, she didn't have to be this mad, is my point. She didn't have to be this mad. She should have gone through and taken that break and looked at the stuff and been like, oh, he's making this doesn't count. This doesn't count. This is moot. No. Instead, what I think she did, personal opinion here, is I think she went and got herself worked up even more on purpose. Because when I first saw any of this hearing, because I was following the stuff with Zach Hughes, where I saw it, when I happened to see, oh my gosh, shit's going down, when I joined the live stream briefly to see what the heck was going on, it was literally right here. And my thought was, I didn't know what was going on. I didn't know what was happening. And I was like, oh my God. I was like, my impression was Judge Bev is acting. Like she's trying to work her, like it's like somebody trying to get worked up. It's like the way the kid would throw a tantrum where they like work themselves up. You know what I mean? It's like that is what happened during that break. Because had she gone through and actually looked at this stuff, she'd be like, oh, this isn't that big of a deal. That doesn't matter. You know what I mean? And instead, it's like she came back more mad. That's just sort of my read on it. So.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever?
Is that even if all of it was true, and this is the thing for me, even if, and it's not like all, like, again, we just went through it, like, blah, but let's just say that every single thing that Hank Brennan just said was true. You know what? That is not worse than, or even not even, doesn't even come close. It doesn't come close to pick any one of the countless things the Commonwealth has done during the first trial, probably before the first trial, I wouldn't know, but during the first trial, after the first trial, the Lallyport video alone. But there's so many things are so much worse. Not only are they just so much worse, but the prejudice matters more because it's towards the defense, right? And Judge Bev, I've never seen her, and when, the big part about being mad, I guess people are saying that because of the handshaking or whatever, I guess. Like, I've never seen her like that, I guess, before. I don't know that I would always notice it, but I guess people would have brought it up if her hand was shaking like that another time. So in other words, it's like, if we're going with like, she's mad and whatnot, right? It's like, and that was my impression, right? At the time was like, she got herself worked up. Like, the thing that is so disgusting is like How is it that this is what you get so worked up about? But look at all the stuff the Commonwealth has done and you never got this worked up. I mean, I don't know why anyone, I mean, I'm not surprised. I mean, we all know she's biased. It's just disturbing. And especially, it's just so hypocritical when we talk about discovery violations. Like, there's still things the defense doesn't have from the Commonwealth. Ugh.
You were dealing with to see if I can in fact get a copy of everything that you just read.
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another TURI request, 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6th, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th, 2025. I think I said the federal government. It was the defense, February 13th.
And so that changes things, right?
2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position.
Wait, let me back that up. February 6th of which year now? Hold on. Let me go back a little bit. Because
the chronology is just.
I was pulling up the scheduling. So I'll just go and tell you guys. I was pulling up the scheduling order to take a look. So I've got that in front of me here. And it says all reciprocal discovery completed is March 6th, 2025. So in other words, on here, there's no deadlines that the defense would have missed for discovery. Reciprocal discovery is not like they haven't missed a deadline for that. Now, again, if it was like for the previous trial, previous year, then that's different. But in terms of discovery that they need to turn over this time around, all reciprocal discovery needs to be completed by March 6th, 2025. So yeah, okay.
December 4th, we sent another TURI request, 2024. January 6th, we filed our notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both.
Did he get the years mixed up? Is that what's going on? Hold on, because this doesn't make any sense. Hold on. Did he get the years mixed up? What is happening?
The chronology is December 4th, we sent another TURI request, 2024. January 6th, we filed our notice.
December 4th, 2024.
Intention to exclude ARCCA experts.
Okay, so that's January 6th, 2025. Okay.
January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6th, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th,
when he says he could engage, hold on.
Had ended with the ARCCA experts and that if either party wanted
What's significant about that to me is it's saying, so this is February 6th, look, February 6th, 2025, that's when their contract had ended with them. So that, again, to me, would make it seem like they were still being paid, right, by the DOJ last summer, right?
The defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th.
When I hear engage, I take that as hired. And what I mean by that specifically is hired as in pay for services, pay for their time, and they're hired as in there's nothing coming in from the DOJ, right? So And let me just think back here real quick. So when they said, yeah, so, and I wonder too, again, going back to Alan Jackson and what he could possibly say, he might be able to say, like, we couldn't hire them because they were still, you know, we couldn't engage them. Like, he's saying this is a change in position. So, yeah. So I think it goes back to that whole thing of like when Alan Jackson was saying you weren't hired by the defense. It's I think it's getting more to the fact that they weren't paying them for their services or their time. But again, we don't know yet. Again, I'm gonna try to just stick to the fact of that bill. You know, I think maybe everyone's getting ahead of themselves because that bill, we don't know anything about it. Again, it's this bill. All it said was it was a bill from ARCCA to the defense. We don't know when it's from. We don't know if anyone ever paid it. And anyway, I think that it's like, that's the part that matters. So, hopefully what'll happen is the discovery gets turned over or whatever, or, if it's available and this is all just nothing, right? Nothing was done wrong. There might not be any issues here at all. That's the thing that I wanted to reiterate, but it just, yeah. So, but welcome back, Kane. Happy to see you again. So right. And so that's where I think it only matters, right, if it was like misrepresenting something, right? And so again, I'm not saying that anything was misrepresented. I'm saying that it might just be that you have to carefully explain why you chose why those words aren't misrepresenting something. You know what I mean? But only if, right? Like only if that money was paid in relation to the first trial, right? Like if that money indeed was paid by the defense, right? And it was in relation to the first trial, you can still, then you could still argue and say, yes, I wasn't misrepresenting anything when we said you weren't hired, right? Because technically they were still hired as in working for the DOJ. We weren't allowed to engage them. And that paying for expenses isn't the same as hired, right? And that, again, they framing that with like, you weren't paid yet. So the where you would run into problems is if the Commonwealth could try to argue and say, well, yeah, but hired implies you will get paid at some point. That's the big distinction, right? As in you will get money at some point for anything versus money for services and time versus expenses. There's going to be the parsing of the words. If indeed the bill was from last year, and if indeed it was paid by the defense, then that's where they're going to be fighting over the meaning of these words. That's what I foreshadow. The
defense provided us the emails that I read, February 13th, 2025. I think I said the federal government. It was the defense. February 13th, 2025. They sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so
So
the
the other thing
information
that
that was
matters is that from what we can tell, because their assignment has ended, the other big takeaway from this means that it looks like the ARCCA dudes are going to have to be hired by the defense. Like this would have been the case anyway. Like this hearing wouldn't change this, right? But in other words, because their thing has ended, it looks like they will be hired by the defense for this upcoming trial. Now, what's funny is like normally you would think that that makes a witness look like they could possibly be more biased. However, after hearing from what we learned in the juror interview, the opposite is true here, where it's like it looks like it would almost be better because they felt like, who's this other third party? You know what I mean? And it would almost be better, you know. So anyway, he changed what about the discovery? Yeah, I think I pointed that out. It might have been before you got here, because we've been listening to this. We've listened to this more than once. Like because that's a non-issue. That's not. We weren't really going over that part. So, I think what's interesting is the dates of when they are not working anymore. And there's something else I was going to say. What was it? Hold on. Let me think. Hang on.
2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
all right. So the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
So there was something else I was going to say though. So, and the thing is, here's the thing though, that even if again, the bill, I keep saying the bill is undated. We don't know if it was ever paid. I think of it as an invoice, right? It sounds like an invoice. It's from ARCCA to the defense. It sounds like an invoice. And like I was saying, it could have been from whenever, because we don't know the date, and it could have been from back when it should have been sent to the DOJ. If it was from last year, we just don't know. However, if indeed it was paid by the defense, and if indeed it was from last year, and if indeed it was just for expenses and for their flights or whatever, and it was not for testimony, it's still a problem because it should have been turned over. Like I gave the example earlier. It's like, it'd be like cheating on your taxes where you put something under the table or whatever, right? Or you like exaggerate, you know how people can cheat on their taxes and shouldn't do it, but like how people can, right? It's like, it's kind of like that, where, if, again, I don't think anybody uses cash anymore, but back in the day, let's say like, if you did something and you got paid in cash, right? And it's like, you're supposed to disclose that, right? You have to put it on your tax. It's similar thing, right? So like, as soon as I saw that there was this bill, it's like, if it was a bill that was paid and it was from last year, because remember, their discovery deadline is not over yet for this year. If it was from last year and it was a bill and it was paid, discovery violation, right? So it doesn't mean it's the end of the world. It's a discovery violation. I think that Judge Bev's reaction makes it seem like all this is a lot worse than it is. And again, her reaction was before she also learned what she's hearing now from Hank Brennan about the fact that some of that discovery was turned over by the defense, right? So, we don't know we don't know what the thing is she's most mad about. Is she most mad about the bill? Is she most mad about, we don't know. And again, when you go through and just rationally look at all the different quote unquote issues he's raised, the vast majority of them are completely moot. And you can prove that from just looking at the trial testimony, although we just pulled it up on the hearing, or we watched it. Okay. Well, then I don't know what other discovery they're asking for, right? I mean, if it was paid, well, it had to be paid by somebody, you know, unless it was from this year. Like if that bill is from this year, then yeah, it might not be, then it's not a discovery violation. And also it may not need to be paid. You know what I mean? But if it was from last year, somebody paid it, even if it was the DOJ, right? Like, you know, unless they just like accidentally sent a repeat bill. I don't know what the odds of that would be. Right. Yeah. I mean, yeah, we would. The discovery. Yeah. I mean, we covered that like, I don't know, maybe 30 minutes ago. That's just one facet of what the different problems could have been. And he's, you know, representing, like, I think that cures that cures some of the discovery issue, right? Okay, the part that he said was sent from the feds was the emails, right? And it was sent from the defense. We still don't know anything about this bill, right? And so I guess it's interesting though, because they turned those emails over and I guess it's not clear where he got the bill from. If he got the bill from, I guess it had to be from the defense because it couldn't have been from the feds because it sounds like they didn't. Well, yeah, I guess does anybody know, or should we just go back? Like, did he confirm that? Was it confirmed this time around that he did get any discovery from the feds? Because it seems like he didn't. Let's just see.
Notice of intention to exclude ARCCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact.
He didn't say the bill, though, came from the defense. We don't know yet.
ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right. So
I mean, it would make sense if the feds sent the bill, gave them that bill because if the bill was a mistake, it went to the defense by mistake and it was supposed to go to the feds and the feds ended up paying it. So that's why the feds have it and then turn it over. That would make sense if that's what happened, right? Like, again, like if it was an accidental thing, like they sent it to the defense, it's like, oh, wait, sorry, we forgot we're still retained by you, blah, blah. And then they transferred it over and then the feds took care of the bill, right? That would make sense why, if indeed that was turned over from the feds, and then there's no violation for anything for the defense on that part. I would imagine. So but I mean, again, it almost seems like you could, it's hard to know it's hard to, you know, you could, I guess, interpret it that the bill is included when he names everything. Like he says they send us the emails and the direct examination outline.
We reach out to the federal.
Right. He didn't name the bill, but I guess you could say, well, that's the only thing missing. So maybe it's just included.
Government again, because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCCA. Obviously, the Commonwealth is in no position to contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right. So
we reached out to the federal government again. let me go back to where he's talking about what he's received from the federal government, because if it's like they reached out to the federal government again and then they were provided that bill, maybe that bill is for, again, I don't know. Let me just see here.
That up. I don't know if it was ever cleared up. And then a bill from ARCCA to the defense for $23,925. That's not Trimble. That's not.
It's just so crazy because that's literally all it is about the money, right? I mean, it's like I just picture like a sticky note with that number written on it, and it's like we don't even know anything about it. Like that's literally what it is. So let me go back here where he talks about the whole TUI process thing again.
It's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolfe writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the responses verbatim, but I gave.
Back far enough.
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're over 500.
But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCCA, and it was represented these experts were hired by the federal government and they provided a report to us pursuant to a TUI request.
Okay.
It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 28.
Again, this is all completely moot because the discovery that happens that he then, it's like when he reads these emails, it's like he's trying to hope that people are going to think that those emails were before that conversation. But again, for anyone who's just now joining us, this conversation happened on June 10th. And we watched it earlier. And then on June 18th was the voir dire day. And then the emails aren't until June 22nd or after. Apart from the one, there's the one email on March 22nd, but that's nothing. I don't know why he even reads that one.
12 and 28/13 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed the TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking.
And this would mean that it seems like he must have then also been provided that quote unquote bill thing must have also come from the defense. So yeah, so all the discovery then, because the only one that I had a question mark about was the bill, but because he didn't name it at the end, but clearly he didn't receive anything, right? It was unresponsive. So that means all of the discovery he's received has been from the defense, including the bill. So, so here's my takeaway on what's happening here. I think what is happening here is I think that this is a reaction to that juror interview, potentially with Turtle Boy, because it makes a lot of sense, right? Like, what are we seeing here? Like, what was it that was talked about in the interview, and what is and you think about again the general consensus about these ARCCA dudes, right? They're beyond reproach. They're experts, and they were unbiased, and they were hired third party, and blah blah blah. And that seems to be such a big deal. And of course, what was so interesting to hear is for the jury, that did not matter at all to them. In fact, it made them distrust them even more, right? So, but just that their opinion was so important. And it's the thing that, like, again, everybody who's being, I think, objective and honest is going to be like, the ARCCA dudes kill the state's case, or the Commonwealth's case rather, right? So it's so interesting. How many times did we hear Hank Brennan say today and previously, I have no problem with the ARCCA dudes. What I hear every time he says that, I hear in my mind, I'm not afraid of the ARCCA dudes. I think that's why he says it. The reason he says, he's like, I have no problem with them testifying. I'm not afraid of the ARCCA dudes. I'm not trying to keep them from testifying. I'm not afraid of the ARCCA dudes. Why? It's trying to send a message, I think, this is my personal opinion, send a message to the public and to the media and what have you, right? Because everybody has been, everybody who's being honest and objective, even a little bit, would be like, the ARCCA dudes killed the Commonwealth's case, and it should have killed it the first time. And now we know, because of the juror interview, that the only reason it didn't kill it is because there were people who were like, oh, well, it's shady because we don't know who hired them. And, and so now we don't trust them or whatever. Right. So in other words, now we have just 2 days later, right? This hearing, Hank Brennan coming in and saying, like, it's like he's trying to posture that I'm not afraid of the ARCCA dudes. It's just the discovery that I want, right? But at the same time, trying to make these suggestions that the defense is slimy and they didn't do this and that. Like, I think it's more about, I think this is really more for show. Like, that's my take on this. It's more for the media. It's more for the public to try to get, because the defense has been beyond reproach. They've not done, to my knowledge, there's not been anything about them doing anything that could even be considered a problem in the first trial or up until now. And same thing with the ARCCA dudes, right? So what is this? This is like trying to say, you guys have it all wrong. The defense is slimy. They're doing all this and that. They're lying about this. The dudes were paid. And so the defense lied about that. And on top of it, the ARCCA dudes are biased. But that's what he's trying to do, I think, right? And that's why, and I think a lot of this could be in reaction to that juror interview. I think the timing is very interesting. And I think it's like spin, like they do in politics or whatever, right? And the defense does not seem bothered at all by any of this. To me, the defense does not seem worried. They seem to think that, like, they're just like waiting for their turn. That's my take on it. It's a shame they don't get their turn. I mean, I agree. Dramatic and ridiculous, 100%. 100%. And I think he saw something that was like, okay, we don't have, he saw an opportunity here to take something and represent it in a way that he could then make it into more than it is. You know what I mean? That's my take on this. And again, to me, it's like, I mean, if the thing is like they turned it over. So I don't know. Again, their discovery deadline for this trial hasn't occurred yet. But let's get to the scheduling. Okay, this is where we were, I believe.
December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude an email. This was a change to exclude February 13th. But that parties could contact ARCCA. Obviously, the Commonwealth is in no position.
Federal government. I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right.
Wait, what did she ask for? Hold on.
Contact ARCCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right. So the information that was provided to you, not from the federal government, I'd like a copy of before you leave.
Okay, not from the federal government. So good. So she at least heard him say that. She heard him recant that. That's why I wanted to back it up, because I was like, wait, did she ask for federal government? Because if she had said, I like the information you got from the federal government, then that means she didn't even hear what he said, right? She said not from the federal government. So, okay.
Before you leave the courthouse today.
Yes, Your Honor.
All right. 11 o'clock, a week from today.
Your Honor.
Is it
So let's go ahead to see what they get to here. I remember they go for a while trying to figure this out.
Just on behalf of Mr. Alessi, is there any chance the court would entertain the?
Your Honor, we'll accommodate the 25th, one way or the other.
Okay.
All right. So we'll see everyone.
I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right. 11 o'clock on the 25th.
Thank you.
All rise for the court, please.
You won't even hear that other thing. Again, there's a lot of issues here, right? There's beyond any of it, on top of any of it, I should say, the thing that pisses me off the most is that Judge Bev, to the extent that she's rattled, has not been like this for anything. And you can't even compare it, right? The violations that the Commonwealth has done they're not even in the same category. And she never gets worked up for Karen Reed's rights being violated ever. She doesn't even care. It's disturbing. I know you guys all know that. Like, it's just disturbing. And that it really comes out. And the way she reacted today, that just goes to show you, right, that the defense has done everything correctly above board. And if this is any type of violation, it's got to be like the first one, Yet time after time after time after time, the Commonwealth there's fuckery and they're violating. They're not trying. Again, the Lallyport video alone, that should have made her explode. That's like the normal reaction, right? And the list would be endless of things that are in that category. And then repeatedly. It would be like having two children. It'd be like if you're a parent, you've got two children, and you've got one child that breaks the rules every day. They're getting in fights at school, and they're eating candy, and they're whatever, and they're breaking the rules all the time. And you're just like, okay, don't break the rules, but like you don't ever scold them in some fashion. And then you've got another kid who has never broken the rule, does all their homework, goes to bed on time, doesn't get in trouble at school, gets perfect grades, whatever, right? And then one day they get like a B+ instead of an A. I'm just coming up with an example, right? And it's like not even in the same category. Like you take the first kid and it's like, let's just say that they're doing all kinds of things. Let's say they're getting in fights or they're stealing things from their classmates, like that. And then it's like you got the other kid and it's like they get a B+ instead of an A. It's like those two things are not in the same category. And then it's like you see the B+ and you like lose your mind. It's like that. It's like that's what this is like to me. Totally agree. And that's the thing. That break was not for her to calm down. I think that break was to like work herself up. I picture her going back in her chambers, just like pacing and being like, rah, 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 like, maybe out loud or maybe in her head. I don't know. What she didn't do is actually assess any of this and take a look, or she would have come back and been like, honestly, she probably would have come. I would hope she would have come back and been like challenging some of what he was saying. Because again, the vast majority of it is completely moot and he's misrepresenting it to try to make issues that don't exist. She should have come back and if anything been angry at Mr. Brennan. Would she ever be? I don't know. She's probably too biased for that, that's the thing. She's never been angry with the Commonwealth. Although you should be angry with them all the time. It makes no sense. And so instead, what does she do? She comes back and she's, I think she was just worried. She's just stewing on it, right? Like just working herself up. And because this is insane. Like her reaction was insane to this. It was so disproportionate to anything that happened. It was unfounded. Anyway, so it's gross. That's basically, that's what it is. It's gross and it's disturbing. And I just really hope that, what could happen here? Like, what's the worst case scenario? I mean, maybe a sanction on Alan Jackson, depending on what happens, right? If something was found to be a violation, maybe a sanction, it could be financial. I don't think she's going to kick him off the case. That would be punishing the defendant. And you really don't want to do that, right? So, again, could it be something like denying, Mr. Better? No, again, you can't be, I don't think so, because that would be violating, due process. She has the right to counsel. You know what I mean? So I think if there is a violation found, and same thing, right? Like, I don't think limiting, and if Judge Bev, the sanction I could see her going for would be like not letting them testify, right? The ARCCA dudes. However, Hank Brennan only said a billion times, I have no problem with them testifying, right? So that's not what he's asking for. And they're going to have a motion for sanctions. And it sounds like he's not going to ask for them not to testify. And again, it's so funny because I think he's just saying that to try to posture like we're not afraid of them. Again, to make it seem like the Commonwealth actually has a case. I think it's for show. But in doing so, he could be limiting her from being able to remove them, right? And so that, anyway, it's in other words, the ego might bite him in the ass is what I'm saying. The ego might bite him in the ass because I think the Commonwealth, like if you're the Commonwealth, you want them to not testify. That's the thing. The only way that the Commonwealth can stand a chance, I think, on a second round, because I think that they got lucky that first time with the jury thinking the way they did, getting rid of the ARCCA dudes. The ARCCA dudes are just so crucial when you look at this objectively and, not based off of craziness like some of the other things. So, like that would be normal. You want the ARCCA dudes to not testify, right? So for him to come up there and say, no, we want them to testify. We're not trying to stop that. Again, it's like your ego is like going to bite you in the ass on that one. Because you should, if you're smart, you would ask for sanctions that would include that in the mix, right? But he's basically said, no, we don't want that. So it'll be really interesting to see. Now, speaking of sanctions, one of the motions for sanctions, anyway, from the Commonwealth just got posted. It's from February 14th, but it just came out. So give me just a second. It just got posted like a few hours ago, or well, it was like after this hearing concluded is when this came out and was available. So it's not long. Okay. So again, it was for the 14th. So Commonwealth's motion to impose. So they already have some sanctions on the table, in other words, right? Impose sanctions pursuant to mass crimp. Now comes the Commonwealth and requests this honorable court, blah, blah. Under mass crimp 48, willful violations by counsel and violations of court orders shall subject counsel to such sanctions as the court shall deem appropriate, including citation for contempt of the imposition of costs or a fine. Now, remember, this rule could apply as well if something is found to be sanctionable from what came up today. Although that was Rule 14. Let me see something real quick. I wonder, let's just see. Okay, so here's Rule 14. I'm just looking at it. Okay, sanctions for non-compliance. Interesting. So I'll read it to you guys so I don't have to unshare, reshare. So remember, as it pertains to the ARCCA dudes, right? That was Rule 14. That's the type of discovery they're working with there. So here's the sanctions for non-compliance for that, is what it says here. relief. So one, relief for non-disclosure. For failure to comply with any discovery order issued or imposed pursuant to this rule, the court may make a further order for discovery. So in other words, you still like turn it over, right? Grant a continuance or enter such order as it deems just. So are any of those severe? No. I guess it would have to be like whatever it deems just. But again, it said you can make a further order for discovery, grant a continuance, as in a continuance for when they have to return the reciprocal discovery, or any other order it deems just. And then 2, exclusion of the evidence. Well, that would be a testimony from the ARCCA dudes. And guess what? He said he didn't want that, right? The court may in its discretion exclude evidence for noncompliance with a discovery order issued or imposed pursuant to this rule, testimony of the defendant and evidence concerning the defense of lack of criminal responsibility, which is, that's just an exception. So basically it's like, yeah, excluding the evidence. And in this case, that would be testimony. So that's not going to happen. So that's as it pertains to Rule 14. Now, as far as Mass Arc Crimp 48, Rule 48 is dealing with a willful violation of counsel. Interesting. So this is interesting. So where's my mouse? Okay. A willful violation by counsel. So that's a distinction from the other one, okay? A willful violation by counsel of the provisions of these rules or of an order issued pursuant to these rules shall subject counsel to such sanctions as the court shall deem appropriate, including citation for contempt or the imposition. So that's what's cited in this document here. Reporter's notes. The rule is intended to supplement rather than supplant or replace the provisions of law relative to the power of the courts to regulate the conduct of attorneys who practice therein and to discipline those whose actions fall short of accepted standards. So this sounds like it's a bigger deal, okay? It says, in addition to the sanctions of citations for contempt and the imposition of costs or a fine, the rule contemplates referral to the Board of Bar Overseers where appropriate. So this is like big trouble. So I guess they still could ask for this as it pertains to the Rule 14 discovery. But I just wanted to read that to show y'all read to you guys. Rule 14 had its own criteria for, because again, that's pretrial discovery, right? Had its own criteria for discovery. Now, again, that makes sense though as to why it said this Mass Arc Crimp Rule 48 says it's to supplement, right? So in addition to that. Okay, so it's even quoted here, right? So the purpose of the rule is to regulate the conduct of attorneys who practice therein and to discipline those whose actions fall short of accepted standard. I'll zoom in too so you guys can see it better. On February 11th, 2025, in the defendant's motion to reconsider reciprocal discovery order, it appears that the defense flagrantly violated protective orders previously agreed to by the defendant and set by this court on November 13th, 2024 and January 31st, 2025. In the defendant's motion, it quotes a text message sent by Trooper Michael Proctor. This text message is subject to the protective orders and the January 31st, 2025 order specifically restricts the public dissemination of all communications, those within the work cell phone of Massachusetts State Trooper Michael Proctor. The defendant attempts to unilaterally amend the protective orders by claiming that only the screenshot of the message of Proctor's text message is subject to a protective order. This is an obvious violation of the protective orders. Further, the defense's claim that the protective orders are limited to personal identifying information is misplaced. Before communications were produced to the defendant, personal identifying information such as phone numbers were redacted. The purpose and necessity of the protective orders, as stated, is to effectuate the well-established privacy and safety interests of witnesses and protect the integrity of ongoing investigations, a recurring issue and concern in this case. Notably, this is not the defense's first violation of a protective order or court rule. The defense has repeatedly displayed autopsy photographs of the victim without permission of the court. What? And has previously filed motions with photographs and names of juvenile witnesses, photographs of the victim's deceased body, and has released witnesses identifying information. I don't know. Again, I didn't follow anything pre-trial from the first trial, so I don't know if that's when that stuff happened, but it has not happened since the first trial because I've followed everything since then. Further, this court previously ruled that it is unacceptable for defense counsel to misrepresent and distort facts in impounded documents and to fail to comply with orders of this court, all of which have happened in this case. The court will not tolerate actions by counsel which waste the court's time and resources or violate the rules. Therefore, Commonwealth moves that the defense be sanctioned to include, but not limited to, being ordered to file all motions under seal and impounded until such time that both the Commonwealth and court can ensure the filings comply with all previous orders set by this court. The content of improperly filed motions serves to taint the prospective jury pool. So that's their only, it says included but not limited to, but like their only thing that they're specifically asking for, right, is filing all motions under seal until the court and the Commonwealth can ensure it's been complied with. So this is not, it's really funny, right? Because it's like, we just read it, the rule, and it's like, it's more severe. It could include being reported to the bar. And now you look at like what they're asking for, and what they're asking for is like, you know, it's just funny. Again, it's like making a mountain out of a molehill yet again, right? Because they're not asking for sanctions to include being reported to the bar, right? Or a fine, or a fine. I mean, all those other things that we read, like this seems like this to me isn't asking, like, in other words, the way that the problem is made out to be is way more severe than even the sanctions being asked for. And usually you see the other way around. Usually you see the sanctions being asked for to seem like that's way over the top for the thing that they're complaining about. And this is the opposite, right? And I wonder if it's going to be the same with what we heard from the hearing today, where it's like they try to make this seem like such a big deal, blah, blah. But then when they have the opportunity to ask for sanctions, remember, he kept saying, we don't want them to be excluded from testifying. Like, it's going to be really interesting to see what they ask for. Because like when you look at this, it's like this to me is not that big of a deal, right? Like if indeed the court goes with what they're asking for, it's like, fine. Their motions are under seal from the public just until they can look at it and be like, yeah, it complies. And then it's not under seal anymore. Like, okay, like fine. Like with all the other options are way more severe. So it's funny, isn't it? It's funny. You guys, what do you guys think about that? It would be like whenever we see something come out for sanctions regarding what we heard in the hearing today, given what the type of fuss he tried to make, it'll be really interesting if like what's in the sanction is like, make sure they comply with turning over discovery. It would be like that. It'd be like, huh? You know what I mean? It's like, just goes to show you, like, he was just, it's like splashing around to like make waves when there's, what's the example they give, right? You try to make it look like there's, anyway, all talk and no walk. I don't know. There's sayings, there's things. Good morning, Iowa. Happy to see you. I mean, maybe, but like, again, those things aren't going to happen, aren't going to happen. And at least here, right, when we're looking at this particular motion for sanctions, right, they say the rule. I mean, the defense flagrantly violated protective orders. They go on and on. And like, it's an obvious violation of the protective order. It's not the first violation. It's unacceptable, right, for counsel to misrepresent and distort facts in impounded documents. I mean, the court will not tolerate actions by counsel which waste the court's time and resource, blah. But anyway, it's just like the sanction is like, the sanction, I guess, is not that bad, right? If anything, it's maybe proportionate in a way, right? But the way they try to describe it and make it out to be is disproportionate. Like, it's almost like hoping that people will just read the title and freak out. You know what I mean? Sort of like what Judge Bev did, right? Judge Bev in the hearing today, perfect example. Hoping that she and the public would just hear what they're saying and not double check it, not look into it, not go back to look at what they've said in voir dire, not to notice that there's no date on the bill and we don't know if it was ever paid, all the stuff that we just looked at, right? And to look at it objectively and just assess it, right? And versus just getting emotional and worked up, right? It's like, it's as if Hank Brennan was hoping, and it worked, right? That Judge Bev would just get all worked up. Well, that's what she did, right? And it's almost like when you look at something like this document, it's almost like hoping that people will just, in mainstream media, what are they going to do? They're just going to comment on literally, oh, there's a motion for sanctions, right? Ha, rawr, whatever, bad, and it's like, but then when you get to the sanctions that they're asking for, it's like a nothing burger, right? So anyway, yeah. I know there's a bunch of drama. You got drama queen with Judge Bev. You got drama queen with Hank Brennan. I guess some people might say that some of the defense attorneys are drama queens, but they don't bother me because they are not in the wrong, and they're not, you know what I mean? They're not infringing upon anybody's rights by being a drama queen. The thing is this, they're fighting for their client. And that's a known thing where, because everything is about protecting the defendant's rights. You know what I mean? It's like, they have to fight, and they getting passionate about arguments they're making. And for example, like what we saw today when we were going back and looking at the thing on June 10th, yeah, like, that there is a place that is far more tolerable, I think, for most people, regardless of what anybody thinks. Like, that's more tolerable. It should be anyway, if you understand how the system works, versus like when you've got the government being really dramatic, especially when the thing is if you can back it up, that's one thing. But when you can't back it up, and when you're that's why I keep going back to the whole thing. They don't have the discovery, right? It's like, in other words, they don't have the proof to back up the type of drama they're making because they don't have the discovery. So it's like, if indeed they had the dates, and if indeed all this was, I mean, again, all of this you can already shoot down for the most part, right? But like, I don't know. It'd be one thing if they had the receipts, right? And they already had the proof that something was going on. That was a violation of the rule or whatever. But that's not what they have. And even then, even if they had that, it would be a first for the defense, when the Commonwealth does this shit all the time. I mean, again, and you think of it that way, the defense has every reason to be dramatic, if you will. They have every reason to be frustrated and upset. And the Commonwealth, anyway, it's just, there's people that like do the crime to play the victim. It's like that. That's what the Commonwealth is like. You know what I mean? It's like when you've got people who are the ones that commit the crime, and then they try to make it look like they're the victim. Like, that's the Commonwealth to me in this case, over and over again. Like as if you were a serial killer, but saying that somebody killed you more than once or something. I mean, that's not possible. But anyway, it's like, or let's just say a serial, I don't know, like, let's just say you're a serial burglar, stealing things. I guess, you steal money all the time or whatever, and you're like constantly stealing from people. Okay. For example, let's take Alex Murdaugh. Let's pretend Alex Murdaugh, so we know he was stealing from his clients. It would be like that, but but he was in turn being like, people are stealing from me all the time, right? It's like that, right? Making up that you're the victim when you're actually the one doing the thing to other people. That's like the Commonwealth. So anyway, so that's why the drama queenness of it all is just not tolerable for me. Whereas I feel like it is warranted. It's warranted. It's warranted when it comes to the defense. But they're not even. That's the thing, right? I'll tell you what, like, Mr. Brennan is like really trying to win first prize for the drama queenness of it all. And again, Judge Bev encourages it. Like it's like they're feeding off each other. It's really gross. And again, you saw that today. Yeah. Anyway, but that's it for this one. We will be back with covering the Zachary Hughes trial. He's expected to take the stand. And I also have, for anyone who hasn't heard me say this already, I have obtained the documents, the motion in limine as it relates to the CP. And I've also obtained the motion to limit Brad Post's testimony, again, relating to the CP. So we will cover those as well whenever we're back to the trial. I don't know yet what time I'm going to cut. I'm probably going to do it later. I think it's just easier than, because especially with like so many things where they just cut the cameras away, like what happened earlier on day, like what happened with day 5, where like, yeah, 5.5 hours of court feed and like 30 minutes of things happening that we can see, everything happening without us being able to see it, unfortunately. But anyway, we'll just see. I will make sure I put something in the Discord. But yeah, and I believe it's snowing here. Anyway, but that's it for this one, guys. So thanks so much for everybody for being here, for being a squirrel. Love y'all. And I'll see you guys next time.